to load, and then I will let you know when you can get going. Okay, you guys are good to go.
Okay, thank you. Good afternoon, everybody. This is round 4 of the Denver Regional High School Mock Trial Tournament. Been a long day for all of us. Well, for some of us, particularly for the students. And just know that the end is in sight for this tournament. I'm David Arkell. I'll be your judge this afternoon. I'm not a real judge. I'm a practicing attorney. I do construction law, but I've been volunteering as a judge in the mock trial program for, I don't know, a dozen years or so, and I coached for a few years before that. I've also been a scoring panelist. And I have done that, and I've continued to volunteer as a judge because I really believe in this program. And I hope those of you students that are new to it have come to appreciate it through all the hard work that you're going through. My guess is that those of you who are veterans who've done it before are doing it again because you recognize its value. It's a great program. You learn a lot of stuff, a lot of hard work for you and your support folks, your parents and your siblings and your friends. But I think it's all worthwhile. And I hope all of you agree with me after you get you hear who how the tournament came out. But I hope, and in addition to all of that, I hope you've had some fun doing this. There've been some grins and some laughs and maybe some developing of new relationships through it. I found that when I was coaching, particularly, getting to know the kids and helping them get to know each other in this context. So enough about that. I am supposed to give you some warnings or reminders, and I'm going to cut that pretty short. One of the things that I do want to mention, though, is please pay attention to the timers. Excuse me, that the information you get as to how much time you have left. And if a timer says stop, please stop. It doesn't do you any good to keep talking, even if you're in mid-syllable. Just stop. And the reason for that is that if you insist on trying even to finish a sentence, the scoring panelists can mark you down for that, can reduce your score. So please don't give them that opportunity. Just say to yourself, the end, and stop. And the other, I think that's really enough. Most of the other warnings are more apropos to a different, when we're on a different platform. But let me go ahead and swear in everybody at this point. So let's start that process. Team members, I'd like to ask you to please raise your right hands. And I think, yeah, I think I can see you all. Team members, do you promise, excuse me, that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Okay, thank you. Members of what would be the gallery if we were live, these are the coaches, the parents, the friends, the other relatives, and so on. Would you please raise your right hands? And you don't have to join us, I'll take your word for it. But do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? Hearing no loud squawks, I'll move on. Scoring panelists, please raise your right hands. Do you promise to adjudicate this mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of mock trial competition?
Yes.
Yes.
Thank you. And lastly, witnesses, please raise your right hand. Do you promise that the testimony you're about to give will faithfully and truthfully conform to the facts, procedures, and rules of mock trial competition?
Yes, Your Honor.
Okay, thank you. With that out of the way, are there any pretrial matters that we need to deal with first from the plaintiff?
Yes, Your Honor. And before I begin pretrial, I'd like to ask, would you like us to introduce ourselves as a team, or shall we just go straight to preliminary matters?
Well, we can do it either way. Let's go ahead and introduce the teams now. And
Okay,
then we can get that out of the way. And then we can do the preliminary matters and go right into open.
okay.
Good suggestion. So go ahead, please, plaintiff, identify your team members.
Thank you, Your Honor. Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Mix Lee Kenny. I use they, them pronouns. And today, along with my co-counsel, we will be representing the plaintiff, Dakota Weirs, in the case of Dakota Weirs versus Lush Fertilizer Incorporated. Today, I will be conducting the direct examination of Dr. Casey Rogers, the cross-examination of Dr. Devin Williams, and giving the closing argument. May I have permission for my co-counsel to introduce themselves?
Please do so.
Good afternoon, Your Honor, members of the jury, and opposing counsel. My name is Miss Mary Walker. I use she, her pronouns, and today I will be giving the direct examination of Carson Durst and the cross-examination of Skylar Weirs.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Ms. Morgan Taylor. I use she, her pronouns, and today I will be conducting the direct examination of Mr. Dakota Weirs, the cross-examination of Blake Doncourt, and giving the opening statement. Permission for our witnesses to introduce themselves?
Yes, please do so.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Mr. Nathan Trong. I use he, him pronouns, and today I am Dakota Weirs.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is JT Timmers. I use he, him pronouns, and today I am Carson Durst.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Miss Grace Trembath. I use she, her pronouns, and today I am Dr. Casey Rogers.
Thank you. Defense?
Good afternoon, Your Honor, opposing counsel and members of the jury. My name is Leah Dino, and today I will be conducting the direct examination of Skylar Weirs, the cross-examination of Dakota Weirs, and delivering the closing argument. At this time, may my co-counsel please introduce themselves.
Please do so.
Good afternoon, Your Honor. My name is Carmela Carboni, and I will be conducting the direct examination of Blake Doncourt and the cross-examination of Carson Durst.
Good afternoon. My name is Annika Obrecht. I will be delivering the opening statement, conducting the direct examination of Dr. Devin Williams and the cross-examination of Dr. Casey Rogers. May our witnesses please introduce themselves?
Please do so.
Good afternoon. My name is Patrick Shack, and I am Blake Downcourt.
Good afternoon. My name is Maisie Bogich, and I am Skylar Weirs.
My name is Max Obrecht, and I am Dr. Devin Williams.
Okay, thank you. Now, let's proceed to some pretrial matters. Plaintiffs?
Yes, Your Honor. The plaintiff has a few preliminary matters to attend to. Firstly, we would ask that any preliminary matters granted to the plaintiff also be granted to the defense.
Certainly.
Thank you, Your Honor. We would first ask that the crossing attorney keep their camera on throughout the direct that they are listening to, so that it makes it easier for them to object and takes less time.
Any objection from the defense to that one?
No objection, Your Honor.
So ordered.
Thank you, Your Honor. We would also ask advice from Your Honor on how you would like us to handle sharing exhibits, since sharing of the screen isn't quite the same as how it would work in an actual courtroom.
Since you asked, my preference is that when you ask a witness to review an exhibit before it's admitted, I would like that witness to have access to the exhibit, not by way of screen sharing, though, to have either a paper copy or an electronic copy on his or her own screen to look at, to answer your preliminary questions regarding the exhibit. And then if the exhibit is admitted, then I ask you to screen share it.
Yes, Your Honor.
And that is the equivalent, as far as this process is concerned, of publishing it to the jury, is the screen share process. But do not, unless it's necessary, do the screen share before the exhibit is admitted.
Yes, Your Honor. So just to clarify, we should ask our witness to just regard on their own screen or on their own booklet the exhibit. And then after we have gone through the whole process, if it is allowed to be admitted, then we shall screen share?
Yes. Yeah, that's the process. And I will tell you, I have my own copies of all the exhibits. And I think the scoring panelists do also. So we can follow along with the preliminary questions before it is admitted or denied.
Perfect. Thank you, Your Honor. We would also ask that as far as technical difficulties go, if there are technical difficulties with screen sharing or Wi-Fi, that time be paused for both sides.
Response to that from defense?
No objection, Your Honor.
Okay, that will be ordered, but I will add a little bit to it, that occasionally we won't realize there's a technical difficulty and either a question will be asked or an answer will be given and nobody will hear it. And if that happens and the timers have run their time through that process when nobody could hear the witness or the attorney asking the question, I want to know that, and I will, if it's appropriate, ask the timers to rewind their time for 20 seconds, 10 seconds, whatever it is, to make up for that time that was recorded that should not have been. Is that acceptable to both sides?
Yes, Your Honor.
Yes, Your Honor.
Okay.
And we would also ask that given the fact that we're competing virtually, our attorneys and witnesses may be allowed to either sit or stand depending on what works best for them in their space.
Response?
No objection, Your Honor.
Well, I think that's in the rules anyway, the Zoom rules or the virtual rules. So, and that's totally fine with me, and I'm sure it is with the scoring panelists as well. So it's so ordered.
Thank you, Your Honor. And finally, we would ask that any remaining time at the end of plaintiff's closing be saved for a rebuttal.
Response?
No objection, Your Honor.
Okay, so ordered. And the timers, please keep track of that during the closing, the plaintiff's closing. Anything else from plaintiffs?
No, Your Honor, that is all of plaintiff's preliminary matters. Thank you.
Anything additional from defense?
Yes, Your Honor, 2 preliminary matters from the defense. We ask that stipulated facts be entered into evidence and constructively be read to the jury.
Any response from plaintiffs to that?
No objection to that, Your Honor.
So ordered.
And finally, we ask that the jury is constructively given jury instructions before closing arguments begin.
I think they already have them, but if you want to bring that up at that time, that's fine. It's okay for them to have the instructions at that point in time.
Yes, Your Honor, nothing further from the defense.
Okay, thank you. I have one thing, it's kind of a personal matter. Anything I've seen here, I don't think it's going to be a problem. But I have a hearing defect and I wear hearing aids, but sometimes they don't work very well. And even in this, or maybe especially in this context, I sometimes have difficulty not with volume, but with discerning the actual words. And it's very helpful for me if when you're speaking, you're not wearing a mask, because I have learned somewhat to read lips on a very elementary basis. But if you don't object to not wearing a mask, I would appreciate your not wearing a mask, just to be sure that I can get full comprehension of what you're saying. I haven't seen anybody with masks today. If that remains the case, that won't be an issue. But otherwise, I would appreciate that accommodation. So thank you all for that. Having gotten that out of the way, plaintiff, are you ready to proceed with your opening?
Yes, Your Honor, the plaintiff is prepared.
Please proceed.
Thank you, Your Honor. How far would you go for money? Would you put profits over people? A young man's future has been stolen from him by an avaricious corporation that is blinded by greed, the hunt for money masked behind the facade of environmentalism. My co-counsel and I have seen the plaintiff, Dakota Weirs, express his newfound struggles, and today we will share his story with you. Members of the jury, I ask you to listen to Mr. Weirs' experiences, and through them, see the consequences of lush fertilizer putting profits over people. They put profits over Dakota Weirs, who deals with crippling pain and whose life will never be the same. We will begin our case by calling Dakota Weirs to the stand, where he will share with you his love for the outdoors and playing piano. You will learn that his passions were stolen from him by non-Hodgkin lymphoma. He will describe the physical and mental pain he suffers day after day, and the emotional losses he continues to endure. Mr. Weirs will then describe his interactions with lush fertilizer and will detail his suspicions of a lurking danger, followed by his realization that Drufo, a vital ingredient used in lush products, is correlated to his condition, despite the lack of a proper warning label. We will then call Carson Durst to testify to his involvement with lush fertilizer. Through his testimony, you will learn how Lush ignored carcinogenic properties of Drufo and how the company chose to not properly continue testing, despite being warned about its harmful effects. Mr. Durst will tell you about being dismissed and ridiculed for advocating for better testing protocols on Lush's products. And lastly, he will tell you about Lush actively prioritizing their profits over people. Finally, Dr. Casey Rogers will take the stand and speak about the causal links between Drufo and non-Hodgkin lymphoma, using her expertise to explain a study that Lush neglected to replicate. She will testify to the fact that Lush's label does not provide a sufficient warning about the consequences of working with Drufo, and how Lush, an international corporation, disregarded their responsibility to adequately warn customers. The defense will call Dr. Devin Williams to the stand to claim Drufo's safety by attempting to discredit Dr. Rogers. But Dr. Williams will fail to explain why Lush didn't see fit to replicate Dr. Rogers' study or conduct one of their own. Blake Doncourt, the CEO of Lush, will also testify on behalf of the defense and will aim to coerce you into thinking he is a humanitarian who truly cares about the environment, but will not explain why Lush refuses to eliminate all forms of risk by baking the fertilizer. The defense will then call upon Skylar Weirs to testify against their own twin and use questionable research to discredit Dakota's pain. We, pursuant to jury instruction number 1, and as representatives of the plaintiff, have the burden of proof today and must prove our case by a preponderance of the evidence, which means to simply prove that something is more probably true than not. Pursuant to jury instruction number 2, we must prove this negligence by showing you that Lush Fertilizer manufactured a chemical product containing Drufo, that they failed to reasonably prevent risk to those using the product in the expected manner, that Dakota Weirs used Drufo in that expected manner, and that Mr. Weirs has damages caused by Drufo, and therefore by the defendant, Lush Fertilizer. The defense will try to convince you that Lush was perfectly responsible in testing and sufficiently warning users, but Mr. Durst will testify to how Lush disregards safety concerns and doesn't allow employees to research further, breaching their duty as a company. Dr. Rogers will explain both the link between non-Hodgkin lymphoma and Drufo and the duty Lush has to investigate any potential dangers. And finally, Mr. Weirs will express the damages he has incurred due to Lush's negligence and irresponsible conduct. These damages are non-economic and include physical and mental suffering, emotional trauma, and impairment of quality of life. Pursuant to the pretrial ruling of Judge Staub, the amount for these damages will be determined here. And Dakota will testify these damages are worth $1,000 a day for the estimated lifetime he has lost, 60 more years. This amount totals to $21.9 million. Now, at the culmination of this trial, my co-counsel will ask you to find Lush Fertilizer liable as a result of their negligence through their failure to properly test Drufo, the resulting tragedy of a young musician's existence torn to pieces, and their continued insistence of putting their profits over people. Thank you.
Defense, your opening, please.
Good afternoon. My name is Annika Obrecht, and along with my co-counsel, I represent the defendant, Lush Fertilizer. The story you just heard is a sad one. It's tragic when anyone gets cancer, particularly someone as young as Dakota Weirs. But plaintiff's counsel isn't telling you the whole story. This isn't a case about profits over people. It's a case about Dakota Weirs trying to find the defendant with the deepest pockets. The plaintiff claims that Lush Fertilizer was negligent in failing to warn its users about Drufo, a bonding agent in its fertilizer. The plaintiff must prove their claim by a preponderance of the evidence, which means more likely than not. The plaintiff will fail to meet this burden. Lush Fertilizer didn't and couldn't know that Drufo was harmful to humans because it isn't. Lush Fertilizer was founded in 2000 by Blake Doncourt. Mr. Doncourt will talk to you about how hard he worked to turn Lush Fertilizer into one of the largest fertilizer suppliers in the world. He will testify about his charitable contributions and the products he created. Drufo is actually a revolutionary chemical that decreases the amount of fertilizer that has to be applied. Less fertilizer means less nitrogen, which is good for the environment and, more importantly, for people. Lush did extensive research and conducted studies on the safety of Drufo. You'll hear more about those studies from Dr. Devin Williams, the head of Lush's research and development labs. He will tell you there is no evidence establishing a causal link between Drufo and cancer. Finally, the defense will call Skylar Weirs the plaintiff's twin sister. She is an investigative reporter who has done extensive research on the potential risks of Drufo. She will tell you that she could not find any study that establishes with any level of certainty that Drufo causes cancer. You will hear that even though she's testifying against her brother, she believes she must stand up for the truth. Dakota Weirs will testify about their summer job at a local company called Haven Landscaping. He will admit that Haven let a 14-year-old boy work with pesticides and fertilizers and allowed its employees to ignore recommendations about safety precautions like wearing masks and protective clothing. So why isn't Haven being sued? The evidence will show that Haven is a small local company while Lush makes millions of dollars. That isn't the only ulterior motive in this case. Plaintiff will call Carson Durst. You will hear he is a disgruntled former employee and a former family of the Doncourts with an axe to grind. He was fired for poor performance and went to work for Lush's competitor. Although he will try to suggest otherwise, he has no personal knowledge of any studies showing a statistical increased risk of cancer in humans from exposure to Grufel. The plaintiff will call Dr. Casey Rogers as an expert. Dr. Rogers will admit she wants you to favor the plaintiff because that may mean more lawsuits, and more lawsuits may mean more opportunities for them to be hired. And Dr. Rogers' study lacks substance. She compared users of fertilizers to non-users, but failed to measure any risks specific to Grufel. You will see that Lush put a warning label on its products recommending that users wear a mask and protective clothing, like long sleeves and pants. Reasonable, simple precautions. The problem is that Dakota Weirs ignored that warning. Dakota Weirs will admit that he knew that he was supposed to wear protective clothing and a mask, but he didn't want to. He ignored the recommendations. He thought it was too hot to be wearing long sleeves. It may be uncomfortable to put the blame on someone who is sick, but the evidence will show the plaintiff did not act reasonably. At the end of the case, the court will instruct you about the law you must apply. You will hear the plaintiff must prove by a preponderance of the evidence that Lush failed to act reasonably and take reasonable care to warn its users. The critical word is reasonable. The evidence will show that Lush acted reasonably at every step based on the science available to it. Dakota Weirs and Haven Landscaping did not. At the end of the evidence presented, we ask the jury finds in favor of the defense. Thank you.
Okay, thank you. Plaintiff, call your first witness.
Yes, Your Honor. The plaintiff calls Mr. Dakota Weirs to the stand. May we ask that his crossing attorney also, there we go. Hello, Attorney Dino.
Okay, Mr. Weirs, you've previously been sworn. Please proceed.
Thank you, Your Honor. Good afternoon, Mr. Weirs. Can you please state and spell your name for the record?
Hi, everyone. My name is Dakota Weirs, and that is spelled W-E-I-R-S.
And could you please introduce yourself to the jury?
I'm Dakota. I'm 20 years old. I use he, him pronouns, and today I'm here to expose what Lush Fertilizer did to me.
Can you tell us a bit about yourself?
Of course. Well, I used to be very involved in my community. You know, I was a member of the National Honor Society. I was president of my school student government. When I had time, I volunteered for the Denver Rescue Mission, and for work, I worked as a landscaping technician for Haven Landscaping. I also play I used to play the piano as well.
I notice you say you used to do these things. Why did you stop?
Well, right before I was headed off to Juilliard for piano, I started noticing that I was tired all the time and that my neck was starting to hurt. And so after all these doctor's appointments and medical exams, I was finally diagnosed with non-Hodgkin lymphoma. And ever since then, my life has deteriorated.
What symptoms led to your diagnosis?
Well, the first thing I noticed was this sudden weight loss and this strange swelling around my stomach. And then my neck hurts and my sides hurts and my chest hurts as well. It's crippling. And now I can't even sit at the piano anymore without bruising or losing my breath. I can't do what I was meant to do.
You mentioned you were going to Juilliard. What happened?
Well, before I was diagnosed, I was very passionate about piano. I was so driven and I worked so hard that I received a full ride scholarship to the Juilliard of New York. Everything seems like it was coming together with my admission and my scholarship, and now I can't accept it. I can't play in my condition.
I'm sorry for your losses, Mr. Weirs. Let's talk about your work. What did you do for Haven Landscaping?
Well, when I was 14 years old, I started working for this local business called Haven. It was a great way to be involved in the community. But when I worked there, I was too young to work with a lot of the complicated machinery, so I mainly found myself in the grounds working with seeds and fertilizers. It wasn't bad though. I mean, I like working with my hands and being outside, especially in Colorado.
What was the atmosphere like at Haven?
Working at Haven was a great way to get paid to do something I enjoyed doing. I remember I was usually instructed to wear certain protective clothing when working with certain products, but sometimes it was just so hot that we just couldn't. I mean, no one really followed those instructions. My boss never really enforced them. But if I had any idea that I could get cancer.
Objection, Your Honor. This is a narrative response. It's going outside the scope of the question.
Response?
Your Honor, would you like me to specify another question for Mr. Weirs?
Well, I will, in light of that response, I will sustain the objection. And if you could break up your questions a little bit, narrative is not necessarily a bad thing in direct, and I don't mind it, but there are some limits, and if you could try to recognize those, I would appreciate it.
Yes, Your Honor. Mr.
Thank
Weirs, Mr. Weirs, why didn't you listen to your boss's suggestions to cover up?
Well, no one else was doing it, and my 14-year-old self was just taking the example of everyone else around me because they didn't seem to think it was a big deal. I didn't know what I was exposing myself to.
And how was your overall experience working at Haven Landscaping?
I actually really liked working for Haven. I just wish I never worked with Lush Fertilizer. That's how I know I was exposed to Drufo.
Now, are you sure you used Lush fertilizer?
Yes, I am.
And have you seen the Lush fertilizer packaging label?
Yes, when I worked at Haven.
Now, do you have Exhibit 1 in front of you?
Yes, I do.
Now, is Exhibit 1 a fair and accurate representation of the Lush packaging you used?
Yes, it is the photo I received from my boss.
Your Honor, I move to admit Exhibit 1 into evidence.
Any objection?
No objection, Your Honor.
Exhibit 1 is admitted for all purposes. Counsel, do you want to screen share it?
Your Honor, we are going to be asking questions about Mr. Weirs' perception, so I do not believe that would be necessary. But if the jurors would like to take a look alongside them so that they can see what Mr. Weirs is seeing, that would be appropriate.
Well, I think they already have a copy. If that's all you need to screen share, we don't need to go through that step.
Okay, Your Honor. Thank you. May I proceed?
You may.
Now, Mr. Weirs, what jumps out at you on the Lush packaging?
Well, on one side, there's the ingredients list. On the other, it has this recommendations list. But what jumps out at me is that the only caution it gives is that it could potentially irritate my eyes.
Now, does the packaging seem to have any warnings?
No, the word warning is nowhere on the label. There's nothing about long-term effects and certainly nothing about cancer.
Now, do you think the packaging mentions anything about the effects of Drufo?
No, only that it's an ingredient. There's nothing about what it can cause or what it can do.
Now, did you ever research the contents of Lush fertilizer?
Yes, I did.
And why did you investigate them?
Well, I was watching the news one day and I saw this story about Lush, or more specifically about Drufo, and how the company had leaked documents that show it's dangerous.
Your Honor, this testimony is hearsay.
May I respond, Your Honor?
Please do so.
Your Honor, this question was clearly asked to elicit the effect on the listener for Mr. Weirs. He is not testifying that the contents of the news story were in fact true. Therefore, this is not being offered for the truth of the matter asserted. Therefore, it doesn't fall under the definition of hearsay.
Response?
Yes, Your Honor. Under Rule 801, I have no objection if this testimony is not being used to prove the truth of the contents of what Mr. Weirs saw on the TV, as long as it's being used to prove his reaction to it. I have no objection, but I would be wary that this testimony does not go into the truth of the Drufo conclusions that were made by that TV segment.
I think counsel has stipulated that it's not being offered for the truth of what the talking head said on the TV. So with that caveat, the objection will be overruled.
And would you like me to repeat the question, Mr. Weirs?
Yes, please.
Why did you investigate the contents of Lush Fertilizer?
Well, about the story, apparently the company, Lush Fertilizer, had lied about its safety. And I was freaking out because I knew I had used the product at Lush and I didn't remember any warnings about it. And, I was concerned it was related to my condition.
Well, did you know Lush uses Drufo?
I mean, it's on the ingredients list, but I had no idea what it was at the time, and I thought it was safe since there was no warnings. But after the story got leaked, I kind of put two and two together and started doing my own research.
Thank you, Mr. Weirs. Now let's talk about your life. How have you observed your twin Skylar Weirs after your diagnosis?
Well, Skylar seems very upset that Dad is prioritizing my medical bills over their own
Objection,
financial.
Your Honor. This is improper character evidence, Rule 404.
Your Honor, may I respond?
You may.
Your Honor, we are not offering this as character evidence, nor are we asserting anything about Skylar's character or actions. We are using this to go to the non-economic damages that Mr. Weirs has incurred through, the stresses on his family and the stresses on his life. These are not being offered to say anything about Skylar Weirs, nor do I think it was.
Reply.
Yes, Your Honor. The testimony was Skylar was upset, and that implies that she had a character trait that she is acting in accordance with at this time, as the question was referring to her testimony today in court. In addition to the improper character evidence, I raise a speculation objection, as Mr. Weirs cannot testify to the mental state of his twin sister feeling upset.
Your Honor, may I respond to both?
Please respond to the statement or the objection, I guess, based on speculation.
The question clearly stated, how have you observed your twin Skylar? And Mr. Weirs said, my twin seems upset. Given that Mr. Weirs has been raised with this sister his entire life, he does have the foundation to understand when she seems upset. He was not testifying that she was upset, only that their relationship has incurred some strain due to their friction.
Objection is overruled. Both objections overruled.
Thank you, Your
Please
Honor.
proceed.
May I proceed?
You may.
I'm sorry, my screen froze, and I believe my internet connection is unstable, but did you say that we could proceed?
You may proceed.
Thank you, Your Honor. Please be wary of any screen freezing. Now, Mr. Weirs, is there anything else your diagnosis has restricted?
Everything I used to do, I can't anymore. I'm not active in my community. My future for college has been ruined. I can't work or do anything, really. My family has been bombarded with these medical bills, and I don't even know if I'll be alive next year. I'm sorry. I don't know why this is happening to me. I'm just so scared.
And what is the aspect of your life you miss most?
Piano. Piano was my life. Ever since I was a kid, I was obsessed with the thing. But when my grandfather died, piano became even more important to me. I remember I would sit at the piano and pretend like he was sitting there right beside me, playing with me. It was how I coped.
And on the whole, how has your life been changed by non-Hodgkin lymphoma?
My life has been destroyed. My dream of living in New York and being a concert pianist has been completely ruined. And the worst part is that I've lost my connection with Grandpa for good. I can't go to Juilliard and I can't accept my scholarship. My life was just beginning, and now the rest of it is over.
Mr. Weirs, how much would you pay to not be in pain today, mental and physical?
Oh, wow. I would give so much.
And if you had to give us a monetary amount?
Today, at least $1,000, enough to compensate for the pain I have to endure hour after hour.
And will the rest of your life ever be the same?
No. The dreams, the abilities I've lost, no, nothing will be the same.
Now, Mr. Weirs, what are you going to do moving forward?
I just hope that through this experience, I can save someone from this fate. Lush needs to be held responsible for what they've done. Hopefully something good can come from this.
Thank you, Mr. Weirs. We have no further questions for this witness at this time, Your Honor.
Cross-examination?
Yes, Your Honor. Mr. Weirs, you worked for Haven Landscaping for 4 years, correct?
Yes, that is correct.
And you started at age 14.
Yes, that is correct.
Your job was to spread seed and fertilizer.
Yes.
And while you're spreading the seed and fertilizer, you like to feel the wind in your face, right?
Yes, especially in Colorado.
Right. And you like to feel the wind in your eyes too, right?
Among my eyelashes, yes.
You knew you were supposed to cover your face when working with these chemicals.
Yes, with certain products.
You didn't do that, did you?
No, I didn't wear them because I didn't know what it could cause. I didn't know that I could end up like this.
Mr. Weirs, you also knew you were supposed to wear long sleeves, pants, and gloves when working with these chemicals, yes?
Yes, but once again, I didn't know that my life could be ruined, that I couldn't play piano if I didn't.
Sometimes you would apply the fertilizers indoors, correct?
Only with products that explicitly didn't say whether or not you could use it in or outdoors, yes.
Because some of the products did instruct you to only use them outdoors, right?
Yes.
But you're claiming that you only use some of the products indoors based off of that warning?
I followed those instructions based on whether or not they asked to be used outdoors or indoors.
So if you didn't read the label that warned you to wear a face mask and long sleeve shirts, then why would you read a label warning you of dangers?
Objection, Your Honor. Lack of foundation for the question and calls for speculation. And I can elaborate that on if Attorney Dino would like me to.
First, let's get a response.
His job is to spread seed and fertilizer, and that he read certain warnings and that he used these products pretty often. I don't see what other foundation I could lay for him to answer a question pertaining to whether he would read a label that's detailing the dangers of Drufo.
May I respond to that, Your Honor?
Please.
Ms. Dino, you have not laid foundation that Mr. Weirs did not read the Lush label. I would ask for some sort of question so that Mr. Weirs can defend himself on that count before we start speculating on what Mr. Weirs would have done if he didn't.
Reply.
Yes, Your Honor. I have asked multiple foundational questions asking him if he knew he was supposed to wear face coverings, long sleeve shirts, and we have clarified that that is what the label recommends. That was on direct examination, and therefore it is foundational at this point. We know that Mr. Weirs has read the label and ignored them.
May I respond and clarify, Your Honor?
Yes.
Ms. Dino has not asked questions specifically about Lush fertilizer and is conflating multiple different types of fertilizer, all of which have different regulations for how and when they should be used.
The objection is overruled. You may go into this further on cross-examination or on redirect.
Yes, Your Honor. Thank you, Your Honor.
Please proceed.
Mr. Weirs, if you didn't read a label warning you to wear a mask, then you wouldn't have read a label warning you of the effects of Drufo, correct?
I did read warnings that warned me to wear certain protective clothing, but in terms of Lush only recommended, and therefore I did not take that very seriously because I didn't know what it could cause and how severe the warning could be.
You read those warnings, but you didn't follow those warnings, correct?
I didn't follow those recommendations. Yes, that is correct.
Moving on to Lush Fertilizer's actual product, can you please turn to Exhibit 1?
Yes. Yes.
Screen share that. Now, you said that this is the same label from the Lush Fertilizer packaging that you worked with, correct?
Yes.
You testified that there weren't any warnings about long-term exposure.
Yes, I said that.
Let's look at the warnings that are on this label. It says, as with any spray fertilizer, utilize protective clothing that covers exposed skin, correct?
Yes, on the next line, though, it says it is
Mr. Weirs,
recommended.
thank you. You answered my question. You didn't.
Objection, Your Honor. This is cumulative under Rule 403.
Response?
Yes, Your Honor. I simply was asking him to read one line of questioning. He was continuing to the next line. And for clarity to the jurors, I just wanted to make sure that we were going line by line.
Reply.
Your Honor, under oath 3, you cannot ask cumulative questions, which is to say that you cannot continue to ask questions about things already in evidence to elicit more evidence on things that are already there. Therefore, asking Mr. Weirs to read out every line of this exhibit is redundant and cumulative.
Objection is overruled. We haven't reached that point, and I will give cross-examining counsel some leeway to continue this line of questioning.
Yes, Your Honor.
See where it goes, see if it really is cumulative. So overruled. Please proceed.
Mr. Weirs, the label also says use of a respirator or N95 face mask is recommended, correct?
Yes, recommended.
You didn't follow what the label says there, correct?
I did not follow Lush's recommendation, no.
I think you can take this screen share down. You testify that other fertilizers and chemicals you used often also had some kind of warning on the packaging, correct?
Yes, they claimed that certain protective gear are necessary rather than recommended.
And these warnings are put in place to help protect the customers, correct?
Yes.
But you didn't pay attention to any of these warnings.
Any of the warnings on the other labels?
Any of the warnings that told you to wear a mask, protective gear?
Sometimes, yes.
Now, you mentioned that you first learned of Jufro through a TV news segment.
Yes.
Were the sources of that segment ever confirmed for their credibility?
No, they were not.
Now, let's talk about your time at Haven. You were 14 when you first started working.
Yes, at the beginning of high school.
And you were too young to work with the machinery, correct?
Yes.
The owners of Haven allowed a 14-year-old boy to work with harsh chemicals when they knew the machinery was too dangerous for him?
Well, I was mainly just spreading fertilizer and seeds. I wouldn't say that's as harmful as working with very scary, complex machinery, but I can't speak for Haven.
In addition to letting you work with these harsh chemicals, they didn't require you to wear the protective gear.
They didn't strictly enforce it.
No, and they didn't require any of the other employees to wear protective clothing.
Once again, they didn't strictly enforce it.
Them enforcing that would have protected you quite a bit, right?
Yes, I believe so. But
You
once
aren't
again, I
suing
didn't know.
Haven, Mr. Weirs. You aren't suing Haven.
I apologize. Can you repeat the question?
Of course, you aren't suing Haven today, right?
Yes, I am.
You are suing Haven Landscaping?
Yes.
My apologies, Mr. Weirs. Aren't you suing Lush Fertilizer today?
If you refer to my witness statements, I says, I am suing Lush Fertilizer because their products made me sick. And I believe line 2 to 3.
I'm going to move on, Mr. Weirs. You aren't suing Haven Landscaping today because their pockets weren't deep enough for you, right?
I apologize.
Your Honor, argumentative.
Response?
I can move on, Your Honor.
Please do so.
Mr. Weirs, what is the exact amount you're suing Lush Fertilizer for?
$1,000 a day, enough to compensate for everything I've endured, which I believe is around $21.9 million for my lifetime.
So you are asking for $21.9 million because you believe your life is practically over, correct?
My life is over. I don't have anything anymore.
Mr. Weirs, you can't play piano or go to work or school.
No, I can't.
You can't go to Juilliard.
No, I can't.
The reason you can't go to Juilliard is because you gave up that scholarship, right?
Juilliard is very competitive and I can't play in this condition, so I cannot keep up with that competition.
Right. You gave up the scholarship even though Juilliard told you they would defer it for 2 years, correct?
They did say that, but in my condition, I'm not sure I will ever get to my previous ability.
Your doctors haven't given up hope, Mr. Weirs.
They have not, which is very good for me.
Yeah, you might be able to do these things in the future, right?
I very much hope so.
Because no doctor or other expert has ever opinioned that you won't.
I mean, my doctor currently has hope, but I can't speak for other doctors.
Mr. Weirs, you're asking for over $21 million for something that might never even happen.
I'm asking for that much.
Objection, Your Honor. Objection, Your Honor. Calls for speculation. Mr. Weirs cannot confirm whether or not this will happen, and that is a premise of the question.
Response?
Yes, Your Honor, this is the exact point of the testimony. Mr. Weirs is speculating on his claim that he's not going to get better, that he's doomed for the rest of his lifetime, and that's what this question is clarifying, that he is speculating.
Reply?
Your Honor, I would then ask that the question be more specific as to the future, because the implication here was that in the present, there is nothing going on in Mr. Weirs' life when that's not necessarily true. I would ask that the question become more specific, and then I can address it on redirect.
The objection is overruled. I think the question was adequately clear and is certainly fair cross-examination in any case. Overruled. Please proceed.
Yes, Mr. Weirs, I'm just going to re-ask the question quickly. You are asking for over $21 million for something that might never even happen.
I'm asking for that amount to compensate for everything I've lost. My relationship with my twin, my abilities, my dreams, my life.
Thank you. Mr. Weirs, no further questions, Your Honor.
Your Honor, may I perform a brief redirect?
Please do so.
Mr. Weirs, to clarify, during cross-examination, you said that you were suing Haven Landscaping. Was that a mistake on your part? And what company did you mean to say you were suing?
I'm suing Lush Fertilizer.
Thank you, Mr. Weirs, for the clarification. Secondly, are you in pain right now, Mr. Weirs?
Yes. Not only am I emotionally just lost, my chest, my neck.
Objection, Your Honor. This is going into the territory of unfair prejudice and cumulative under Rule 403.
May I respond, Your Honor?
You may.
In the pretrial ruling, it said that we were meant to demonstrate the non-economic damages that Mr. Weirs is going through, and the pain of non-Hodgkin lymphoma cannot be understated. Mr. Weirs needs to testify as to not only the pain that he has incurred in the past, but also the pain that he is going through right now in order to properly emphasize the and breadth of these economic damages.
Reply?
Yes, Your Honor. It has been blatantly expressed to the jury the pain that Mr. Weirs is suffering right now and will suffer to the future. That has been clarified on direct and cross-examination. I think at this point, the testimony that is going to be repeated is going to bias the jury to make a decision based off of emotions such as sympathy, instead of based on the facts and the evidence.
The objection is overruled. Please proceed.
Mr. Weirs, would you like me to restate the question?
Yes, please.
Are you in pain right now, Mr. Weirs?
Yes, I am. Sitting down hurts a lot. Not only am I in physical pain, I'm also in emotional pain as well.
Thank you, Mr. Weirs. No further questions for this witness at this time, Your Honor.
All right, thank you. Please call your next witness.
Your Honor, the plaintiff calls Carson Durst to the stand. May I proceed?
Mr. Durst, you have previously been sworn.
Yes, Your Honor.
Now please proceed.
Thank you, Your Honor. Good afternoon, Mr. Durst. Could you please state and spell your name for the record?
Hello, my name is Carson Durst. That's D-U-R-S-T.
And what is your profession?
Currently, I am the lead product developer and head of the research and development team for Terra's Greenery, a fertilizer company.
Career in fertilizer.
Well, I started my quite illustrious career as an intern at Lush Fertilizer. I was hired there in 2003, but I rose very quickly through the ranks and became a product development engineer after just 3 months, which I believe is a testament to the high level at which I was performing.
And how did you get this internship at Lush?
Well, my best friend growing up was Charles Doncourt, who's the son of Lush Fertilizer CEO, Blake Doncourt. We both went to ASU College, where I got my bachelor's in chemical engineering. And approaching graduation, I admit I was having a bit of trouble finding a job. Charles told me that his dad, Blake Doncourt, could pull some strings and get me a summer internship at Lush, and that's simply not an opportunity I could pass up.
Right. So what were your responsibilities when you first started at Lush?
Was an intern, my first big assignment was helping in a study to test the safety of Drufo, which was a chemical bonding agent in Lush Fertilizer. More specifically, I personally was tasked with researching a chemical compound in Drufo, C3NO9P, or nitrogen phosphate.
And how do you go about researching this?
Was part of that research, I found one study from England, which concluded that this compound may be carcinogenic in rats, but find any studies which explored whether the chemical compound had any harmful effects in humans.
Thank you. And let the record reflect that I'm showing Mr. Durst a copy of Exhibit 3. I trust you have a copy, Mr. Durst. Do you recognize it?
Yes, it is the study that I found on the carcinogenic nature of C3NO9P in rats.
And is this a fair and accurate representation of that study?
Yes, it is.
Then, Your Honor, I move to admit Exhibit 3 into evidence.
Any objection?
Yes, Your Honor, hearsay.
Response, Your Honor.
You may.
Your Honor, we are not using this for the truth of the matter asserted. We are simply using this study that Mr. Durst found to ensure that Blake Doncourt and Lush Fertilizer were on notice that Drufo was indeed carcinogenic.
Your Honor, if this goes to show the truth of the matter that it is carcinogenic, it is showing the truth of the matter asserted that Mr. Doncourt was informed that it was carcinogenic, and there is no proof that it was brought to his attention.
Objection is overruled. Please proceed.
Thank you, Your Honor. And I have no need to screen share it, although it's okay, timer, thank you. And Mr. Durst, what did you do with this study?
Everyone involved kept notebooks that were reviewed by our superiors, and I put this study in my notebook and sent it to my superior, Jerry Langley.
So what happened to those notebooks after Jerry had them?
Well, supposedly, Ms. Langley reviewed them and compiled them into a study that was sent up to senior management. Unfortunately, that was above my pay grade at the time, and so I did not see the study to confirm that the English study I had found was included in the final study.
Thank you, Mr. Durst. Now I'd like to talk about what happened after your internship. Did you take part in any other studies with Lush?
Yes, right after I received my promotion to product development engineer, which was in September of 2003, Lush conducted a second in-house study relating to Drufo. This time it was studying the potential carcinogenic nature of Drufo in humans, more specifically, in response to the first study that I discussed.
And how did you get started in this study?
Well, my boss, Jerry Langley, emailed me and the other product development engineers, inviting us to take part in the study.
And did you keep this email?
Yes, I did.
Let the record reflect that I am showing Mr. Durst a copy of Exhibit 4. Mr. Durst, do you recognize this document?
Yes, this is the email that I received from Jerry about the study in September of 2003.
And is this a fair and accurate representation of that email?
It is.
Your Honor, I move to admit Exhibit 4 into evidence.
Any objection?
Yes, Your Honor. Authenticity, hearsay, and in addition, the publication of this document would violate a confidentiality agreement signed by Carson Durst and Lush Fertilizer.
Would you please respond to all of those objections one at a time, please?
Yes, Your Honor. In regards to hearsay, it is an opposing party statement and admissible under Rule 801 D2D. And in regards to the authenticity, it is admissible under 1004 because the party against whom the original would have been offered did have control of the original. And if you could remind me what the third objection was, Your Honor.
Please restate your third objection.
In addition, the publication of this document would violate a confidentiality agreement signed between Carson Durst and Lush Fertilizer.
Your Honor, I believe that this document does not reveal any trade secrets because it was made in 2003 and Mr. Durst printed it out in 2003 and does not violate that document that he signed.
The authenticity, that objection is overruled. And the hearsay overruled also. It is a statement by the opposing party. And as to the confidentiality, I have trouble in there, so that one's overruled also.
Thank you, Your Honor.
Please proceed.
Mr. Durst, what does, actually,
Well,
excuse me, Your Honor.
Well, before, let me just make it official or formal. Exhibit 4 is accepted into evidence for all purposes, as is Exhibit 3 also.
Thank you, Your Honor. If my timekeeper may, please screen share Exhibit 4. Mr. Durst, what does this email say?
Well, generally it says that the second study was being conducted to research potential carcinogenic qualities that were found in Truffaut in the June study. It also states that we, as all the product engineers at Lush, should meet with senior management to be briefed on target market positions and economic strategies that were planned for Truffaut.
Thank you, Mr. Durst. Thank you, timekeeper. I no longer need it on screen. So, Mr. Durst, what did you take this to mean?
Well, to me, this seemed to imply that we should present our results and analysis in a positive light to promote the financial success of Truffaut. This was also made more clear in our weekly meetings.
And what did you do with your analysis once you finished the study?
Well, once we reached all our conclusions, we had one final meeting to present all of our analysis and findings to my boss, Jerry, and an upper echelon manager named Alex Monroe.
And what happened at this final meeting?
At this final meeting, one scientist expressed concern that not only may Truffaut contain a carcinogen, but that her analysis found it perhaps linked to non-Hodgkin lymphoma.
Objection, Your Honor. Move to
What's
strike.
your objection? I'm sorry.
Hearsay.
Response?
Yes, I believe that Mr. Durst has said that a scientist expressed, and Mr. Durst did not state the exact phrasing that the scientist said. It is also an opposing party statement under 801D2.
Reply, please.
Yes, the plaintiff has not laid the proper foundation to fall under this exception. This person is not stated and was not authorized to speak on the company's behalf.
Response, Your Honor.
Yes, please.
I believe Mr. Durst just said that they were in a meeting held by Lush Fertilizer, and it can be reasonably assumed that everyone in that meeting was an agent or employee of Lush Fertilizer, including that scientist.
I'm going to overrule this objection. I think there's enough internal indication in the exhibit that would allow the inference anyway, and I think it's a strong inference that everyone that's attending it is an employee of Lush, and I think that's enough basis to allow it into evidence as a statement of opposing counsel. So overruled.
Thank you, Your Honor.
Please proceed.
And how did Alex and Jerry react to this meeting?
At the end of the meeting, Alex Monroe told everyone to keep it in the walls until they figured out what we were doing.
Objection, Your Honor. Move to strike hearsay.
Response, Your Honor.
Response?
From my previous objection, this is another opposing party statement made by an employee of Lush under Rule 801 D2D.
Reply?
Your Honor, this still has not been clarified of the foundation for the opposing party statement.
Response, Your Honor.
Objection overruled. Please proceed.
After this meeting, was this study published?
It was published within Lush Fertilizer. It was reviewed first by upper management and then distributed to higher level employees at Lush, including myself and all the other product development engineers involved.
So when you read this study, what did the study say?
Well, the study concluded that first and foremost, further analysis was required in order to determine if Truffaut causes any long-term health effects like cancer.
Did Lush suggest, what did the study suggest Lush do about this potential risk?
Well, the main thing it suggested was baking the chemical Truffaut to completely eliminate the possibility that it be considered a carcinogen.
And you, as an employee of Lush, did you know if Lush did anything with this information?
No, Lush did nothing. The study, which, as I've said, was conducted by Lush, it seemed to frame baking Truffaut as completely above what was necessary, which happened to comply with what senior management seemed to want in the meetings that we had.
Thank you. And I'd like to move on to what ended your career with Lush. So could you walk me through about what happened there?
Yes, of course. Pretty recently after the second study, my coworkers started filing complaints that I did not deserve the promotions I was getting. This is wildly unfounded, of course, and I brought it up with Blake, who I thought I could trust, but he told me to deal with it myself, which that's really what ended my career with Lush. It made me realize that I needed to start looking out for myself and that I wasn't going to receive what I needed at Lush Fertilizer.
So why did you decide to go work for Terra's Greenery?
The main reason was that they were hiring for my position when I started looking for jobs. I knew it would get Blatesco, and it hurt that I had to betray him like that after he betrayed me, but I had to look after myself now. And I felt that the best way to do that was going to work for Terra's Greenery in 2006.
Thank you, Mr. Durst. Thank you, Your Honor. I have no further questions for this witness.
Cross-examination?
Good evening, Mr. Durst. After you graduated from college, you got a job as an intern, right?
Yes, that's correct, at Lush.
And then after Blake Doncourt pulled some strings for you to get this job, you assumed you didn't have to work as hard as everyone else.
No, I was working harder than everyone else, but and my promotions actually showed that. People were just getting jealous that I was getting promotions and they weren't.
Well, you received bad performance reviews.
Yes, from the same coworkers who were jealous of my promotions.
Multiple people reported your work as unsatisfactory.
Yes, again, the same coworkers.
You complained to Mr. Doncourt.
Yes, I did.
He wasn't very sympathetic, was he?
No, he told me that I should deal with it myself, but I attribute that to the stress he was under at the time.
That made you very angry.
It made me angry at first, but after a while, I realized that I needed to just look after myself.
You believe you were mistreated.
Yes, I do.
You felt betrayed.
Yes, I did.
You were later fired from Lush.
That's correct, in 2006.
At that time, you already had a job lined up at Terrace Greenery.
Yes, they were hiring for my position when I realized that I needed to look after myself. And so I applied for the job and got it. Lush wasn't too happy when they found out, though.
You applied in early 2005, almost 2 years before you were fired, though.
It wasn't exactly 2 years, but yes, it was generally.
You thought applying at Terra would get Blake's go, as you stated previously.
I knew it would, but the main reason was that I could look after myself.
Your Honor, permission to address the witness and show opposing counsel has previously been marked as Exhibit 5.
Certainly.
What is Exhibit 5?
This is the non-compete agreement that I signed with Lush Fertilizer when I started my employment there in 2003.
And this is your signature on Exhibit 5?
I'm sorry, could you repeat that?
Your signature on Exhibit 5, the bottom of the page.
Yes, it is.
Is it a true and accurate copy of the agreement you signed?
Yes, it is.
Your Honor, defense offers Exhibit 5.
Any objection?
Yes, Your Honor, I object to relevance.
Response?
Your Honor, this document shows that Mr. Durst agreed to keep certain things confidential in this contract. It is relevant to the admissibility and authenticity of Exhibit 4, even though it has previously been admitted. It goes to the weight the jury should give the exhibit.
Reply?
Your Honor, this non-compete agreement was from 2003. It has no relevance as to the case that we are here disputing today. And Mr. Durst is well aware of this non-compete agreement, and this was a previously handled dispute.
Your Honor, may I respond?
I will overrule the objection and allow counsel to proceed further in this line of questioning. But counsel, if you wish to renew your objection regarding relevance or anything else, based on following questions, you may do so. But it's overruled for now.
Thank you, Your Honor.
Mr. Durst, can you please look at paragraph 2?
Yes, of course. Is that the second paragraph in section 1 or section 2?
In section 2.
Thank you.
The employee will not at any time or in any manner, either directly or indirectly, divulge, disclose, reveal, or communicate.
Objection, Your Honor, 403.
Response?
Your Honor, I'm simply stating what's in the document and reading word for word. It's non-prejudicial.
Response, Your Honor.
You may.
I was objecting on the grounds of 403 as needlessly cumulative. The evidence has been published to the jury, and there is no need for Mr. Durst to read along line by line.
Objection is overruled. Please proceed.
The employee will not at any time or in any manner, either directly, indirectly, divulge, disclose, reveal, or communicate any trade secret belonging to Lush to any third party, including but not limited to any competitor of Lush. Did I read that correctly, Mr. Durst?
Yes, you did.
Now, can you please look at Exhibit 4 in front of you? This is the email you claim to have received when you were employed at Lush, correct?
Yes, it is.
You don't work for Lush now.
I'm sorry, could you repeat that?
You don't work for Lush now?
No, I work for Terrace.
And this email isn't authentic, is it?
It is authentic. I printed it out in 2003 immediately after receiving it from my superior, Jerry Langley.
You created it.
I mean, I printed it out, but Jerry Langley was the one who originally created it before sending it to me and the other product development engineers.
Well, assuming this email is authentic, it deals with the development of Drufo.
It more deals with testing Drufo, specifically whether it's carcinogenic in humans.
It discusses the company's plans to test it, correct?
Yes.
Drufo's patented, isn't it?
Yes, it is.
And you took it with you when you left your employment at Lush.
No, I did not.
Objection, Your Honor. This is outside of the scope of my witness's witness statement.
Response?
This is directly in the witness's witness statement. I would like to pull it up. Mr. Durst, you remember giving a witness statement, right?
Yes, I do.
You signed it?
Yes, that's correct.
Your Honor, permission to show the witness their witness statement?
You may.
And we will go to line 51. This email is not completely clear, but the agenda was made clear during weekly staff meetings, and there was certainly pressure from management on the internal studies to be read in a certain way.
I'm sorry, was there a question?
Right. Line 51. I believe I read the wrong thing. Exhibit 4 is a printout I kept from one of the emails. Is that correct?
Yes, that's correct.
It contains highly confidential information.
It's not highly confidential. It doesn't relate to any trade secrets at Lush, but it was an internal study that was being conducted.
It's a highly
I'm sorry, you cut out. Could that
It's a highly confidential trade secret.
the fact that they did a study? Is that what you're referring to?
The product, Drufo.
I'm sorry, could you repeat that? You're cutting out for me.
The product, Drufo, is a highly confidential trade secret, correct?
The way to create it is yes.
Your Honor, at this time, defense renews its objection to Exhibit 4, and we move to strike it in all of Mr. Durst's testimony relating to it.
Response?
Your Honor, I am a bit confused as to what counsel is objecting to in Exhibit 4. There is not an ingredient list for Drufo in this. It is simply articulating that Drufo has been examined and tested and studied. There is no trade secrets in this exhibit.
Reply?
I can make an offer of proof, Your Honor. May I make an offer of proof?
Well, let's move on. I am going to deny the motion to strike. I still don't see anything that rises to the level of a trade secret that may violate in Exhibit 4, that may violate the condition of the non-compete agreement. So let's please move forward.
Yes. You testify you reviewed a study relating to the impact of Drufo on rats, correct?
Yes, well, I was an intern.
And you say you reported the study in a journal.
I did, yes.
But you have no personal knowledge about whether Jerry Langley or anyone else at Lush actually saw your journal.
I would presume Jerry did, considering I sent it to her and she was supposed to review all of our notebooks. But I have no proof that it was included in the report later sent out.
During your research, you never found any study involving Drufo and humans, did you?
No, I did not.
No further questions, Your Honor.
Any redirect?
No redirect, Your Honor.
Okay, thank you. Plaintiff, please call your next witness.
Yes, Your Honor. The plaintiff calls Dr. Casey Rogers to the stand.
Dr. Rogers, you've previously been sworn. Please proceed.
Thank you, Your Honor. Good evening, Dr. Rogers.
Good evening.
Would you please introduce yourself to the jury?
Of course. Hello, my name is Dr. Casey Rogers. That's Rogers. And I'm a professor at UC Berkeley in the Horticulture and Entomology Department. And I know plants and bugs sound super boring, but I promise you it's a lot more interesting than it sounds.
And what else do you do when you're not teaching?
Well, when I'm not taking care of my beetles, Ringo, Timothy, the big one, and Vanessa, I'm usually conducting my own research, specifically in the field of toxicology relating to fertilizers and pesticides. And I actually currently work over at the Environmental Chemistry and Toxicology Laboratory.
And would you tell us more about some of this research that you've conducted?
Well, I've actually been publishing work since 2003 in multiple topics, but all within the field of horticulture. But I focus most of my time studying Drufo, both in relation to the plants it's used on, as well as its effect on the people who use it.
So Dr. Rogers, it sounds like you have a lot of very interesting stuff on your plate. Would you just explain how you got to this point in your career?
Well, I started out by getting my bachelor's of science in agriculture and chemistry from CSU. And after I graduated, I began work as a research analyst until I got my PhD from UC Berkeley in the agriculture and my PhD from UC Berkeley in agriculture and entomology. Sorry.
And would you mind sharing a little bit more about what you did as a research analyst?
Of course. Well, I can't tell you exactly where I worked, but what I can tell you is that I worked with several chemical industry clients, helping them to synthesize, analyze, and summarize data for their businesses. And I did this both through conducting my own research and compiling this data into a written product.
Thank you, Dr. Rogers. Your Honor, I now move to tender Dr. Casey Rogers in the fields of horticulture, toxicology, and research analysis.
Response?
May I have a brief voir dire, Your Honor?
You may.
Dr. Rogers, you aren't a cancer specialist, are you?
No, I don't specifically study cancer.
And you've never been to medical school, have you?
No, my PhD is not in medicine.
And you've never worked in a hospital, have you?
No, I haven't.
And you've never had any education or training in diseases of the lymph system, correct?
No, but I am familiar with them just through my work.
But to answer my question, you've never had any education or training in it specifically, have you?
No, but I do have some bit of experience of just the basics.
Your Honor, we don't have an objection to what the plaintiff is admitting Dr. Rogers in, but we do ask for a limiting instruction on medical testimony or opinions. Due to Dr. Rogers' witness statement, we have concerns that Dr. Rogers will attempt to testify on the mechanisms of non-Hodgkin lymphoma, the symptoms, the survival rate, the treatment, or the diagnosis. Under Rule 702, an expert needs sufficient education or training in order to give expert opinions, and Dr. Rogers does not meet those qualifications in terms of medical opinions.
Response to that?
Your Honor, I have no problem with counsel's clarification and limiting instruction. The only thing that I would just be clear on is that toxicology does involve the study of how toxins affect the body. So the only medical expertise that I would have Dr. Rogers include would be within the bounds of toxicology. But other than that, I am completely in agreement with opposing counsel.
Okay, what we're going to do is I will deem this witness qualified in the fields of horticulture, toxicology, and research analysis. And this witness may testify through opinion evidence pursuant to Rule 702. And counsel, if, or probably when, there's a question that you think verges too far into the medical field, you may renew an objection or state an objection regarding testimony being elicited beyond the scope of this expert's expertise, and we'll deal with it at that time in the context of that specific question or series of questions. Please proceed.
Thank you, Your Honor. Moving forward, Dr. Rogers, we both know that DRUFO plays a central role in today's case. Would you just explain to the jury a little bit more about what DRUFO is?
Of course. Well, essentially, DRUFO is a compound made of nitrogen, phosphorus, and potassium that works as a sort of preservative to keep fertilizer intact for longer periods of time.
Thank you, Dr. Rogers. And when did you first hear about DRUFO?
Well, I first heard about DRUFO when it was first being developed by Lush around 2003, but it really caught my attention when they first released it to the public because it seemed to me as though it was rushed to market.
And if you first heard about DRUFO in 2003, why are you still studying it today?
Well, in the following years, I had heard numerous reports of the potentially negative effects of DRUFO, along with reports that had been found to be carcinogenic in rats. And it troubled me that I never saw any of these issues addressed or studied further by Lush. It's actually a large part of what prompted me to conduct my own study regarding the safety of DRUFO.
And Dr. Rogers, switching gears slightly, let's talk specifically about that study. Will you just tell us what it entailed?
Well, the purpose of this study was to find how different levels of DRUFO exposure corresponded to cancers like non-Hodgkin lymphoma. I used 3 groups of people over the course of years to conduct this study.
And would you tell us a little bit more about these groups of people?
Of course. Well, like I said, I observed 3 groups, each with a different level of exposure to Drufo. One with no exposure to Drufo, one with a moderate amount of exposure to Drufo, and one with a high level of exposure to Drufo. And those who were exposed to Drufo included people like farm laborers and gardeners. And I followed these groups both in the years during their exposure, as well as monitoring them in the years after for various health conditions.
And after examining these groups, what did your study conclude?
Well, the study actually found that there was an increase in serious health conditions in those who were exposed to Drufo. More specifically, that those with prolonged exposure were 10 times more likely to develop cancers like non-Hodgkin lymphoma as those in the no exposure group, and 5 times more likely to develop it as those in the only moderate exposure group.
And Dr. Rogers, excuse me, but I'm just still confused about one thing. All of the people in this study had lives aside from their work. I mean, couldn't something other than Drufo have caused the cancer?
Well, actually, the variation in the lives of the subjects aside from their work is very important to the validity of the study. Of course, there's a minimal chance of something else could have caused the cancer in one of the subjects. The fact that the only common denominator for all the test subjects was exposure to Drufo, and the high exposure subjects were far more likely to develop non-Hodgkin lymphoma, points to Drufo as the only plausible link between all the subjects.
Thank you for that answer, Dr. Rogers. And did you hear Mr. Weirs testify earlier about the labels Lush Fertilizer puts on their products with Drufo?
Yes, I did, and I'd actually love to talk about it.
Of course. Your Honor, may I have permission to pull up to show the witness previously admitted exhibit number 1? Oh, Your Honor, I think you're muted. I believe you're still muted, Your Honor.
Yes, let me explain that where I am right now is right above the garage in my house. And I muted myself because my spouse is doing some errands and she just ran the garage door, and it's going down right now. I just didn't want that to interrupt. Probably wasn't worth it.
Thank you for that consideration, Your Honor.
Timekeepers, none of that time gets charged to anybody. That's my explanation of why I have muted myself. But I presume my wife will be gone for a good period of time, an hour or so. So I won't have to do that again. So, sorry for the interruption. Please proceed.
May we pull up previously admitted exhibit 1, Your Honor?
You may.
Thank you. Now, looking at this label, Dr. Rogers, would you just explain how the warnings relate to what you found in your study?
Of course. Well, I would like to point out at first that this is just a general recommendation for fertilizer, not specifically for Drufo. And so, of course, it mentions to wear, long sleeves and a face mask, but these are not requirements to use this product. These are only simply recommendations. And nowhere on this label does it mention that Drufo is potentially carcinogenic. So it does not stress nearly enough how important it is to follow these recommendations.
And Dr. Rogers, one final bit of questions. As you know, Dakota Weirs is currently battling cancer, non-Hodgkin lymphoma specifically. Would you tell us how much experience you have with Mr. Weirs' case specifically?
Of course. Well, in preparation for this trial, I reviewed both Mr. Weirs' medical records as well as all of his employment records in order to gain a better understanding of his level of exposure to Drufo as well as his current medical condition.
And what, if any, opinions do you have about what caused Dakota Weirs' lymphoma?
Well, after reviewing Mr. Weirs' case, I found that his level of exposure to Drufo was very similar to those in the high exposure group, and that it seems to me as though that there's a high degree of probability that his non-Hodgkin lymphoma was caused by his exposure to Drufo.
Thank you, Dr. Rogers. Thank you, Your Honor. I have no further questions at this time.
Cross-examination?
Dr. Rogers, you're hoping that the plaintiff is successful here, correct?
Yes, I am.
You want the door to be open for some class action lawsuits involving Drufo, correct?
Of course. Mr. Weirs is not the only one that's been affected by Drufo.
And if there are more lawsuits, you hope you'll be hired more.
Well, I feel certain responsibility to those in Mr. Weirs' position.
But that could mean a lot of money for you, couldn't it?
I mean, I suppose so, but really, I just feel like a responsibility to those in Mr. Weirs' position. to
Dr.
make sure
Rogers,
that
let's move on to your study. You had 3 groups, correct?
Yes, I did.
One group had never been exposed to Drufo, correct?
Yes.
And that was your control group?
Yes.
And then one group had used products containing Drufo on occasion, correct? You never defined occasional exposure, did you?
I thought it was pretty clear that occasional exposure meant occasional exposure, but I'm happy to elaborate if you want.
Okay, so could occasional exposure be once in a month?
I suppose so, yes. Occasional is just...
Could occasional exposure be once in a week?
Yes.
Could occasional exposure be just in the summer?
I think the occasional exposure meant like the total amount of time that they had been exposed to Drufo.
So less than regularly, correct?
Less than every single day.
Let's move on. You reviewed Miss Weir's employee records, correct?
Yes, I did.
Miss Weir's only had exposure to Drufo during the summer, correct?
Yes, but it was constant, repeated exposure during the summer.
But she wasn't using Drufo or other fertilizers as much as farm laborers, correct?
I suppose so.
Objection calls for speculation.
Fonz?
Yes, Your Honor. I'm referring specifically to Dr. Rogers' own study, which she is an expert on. It's her study. I believe it is within her area of expertise to comment on the workload of farm laborers, specifically since they are people that she studied.
Reply.
Your Honor, I would simply ask that a bit more foundation is laid because while Dr. Rogers did review Mr. Weirs' employment and medical records, Dr. Rogers can't specify to exactly what Mr. Weirs was doing every day.
The objection based on speculation is overruled. This is fair cross-examination, and you can certainly go back to it on redirect if you want to take that step, counsel.
Yes, Your Honor.
It's overruled. Please proceed.
Okay, Dr. Rogers, let's move on to your third group. Your third group was exposed to Drufo on a regular basis, correct?
Yes.
And this group include laborers who used fertilizer in the field, correct?
Yes.
And also gardeners, correct?
Yes, those are just some of the occupations of people who were exposed to Drufo.
But farmers and gardeners don't have the same duties, do they?
I guess not, but they are both using Drufo on a regular basis.
Let's move on. Drufo wasn't the only chemical that these laborers were exposed to, was it?
I would assume not, but like I said before, I was really focusing on exposure to Drufo, and that was the only common link between all of the subjects.
But to clarify, there were other products that these farm laborers were using, correct?
It's possible, yes. That
And
really
these chemicals could have possibly caused the cancer, correct?
Like I said before, it's possible that 1 or 2 of the subjects had their cancer caused from an outside source, but like I said, the only common link was their exposure to Drufo. So it's
at the point that these farmers and people within your prolonged exposure group were exposed to other products, and you say that this could have led to cancer, you have no knowledge whether the increase in cancer was caused by Drufo, do you?
I'm sorry, I don't understand the question. Can you repeat it?
Yes. You have no knowledge whether the increases in cancer was caused by Drufo, do you?
Yes, I do. That was the point of my study.
Let's move on to your mitigation recommendations. As part of your study, you made some recommendations about how to mitigate and prevent exposure to Drufo, correct?
Yes, I did. But I will say that these results were inconclusive, as many workers are not given proper access to this equipment. So we're not even sure if this level is sufficient against Drufo.
So your own study is inconclusive?
No, just this part, because like I said, many workers are not given access to equipment like masks.
Okay. So regardless of the inconclusiveness, you did suggest that workers wear an N95 mask, correct?
Yes.
And you did suggest that they wear protective clothing, correct?
Yes, but again, we're not even sure if this level is sufficient enough.
Okay, but Dakota Weirs didn't take those simple precautions, did he?
From what I heard earlier, no.
And From what you heard earlier, the Lush Fertilizer label recommends that users use protective clothing and a mask, correct?
Yes, it recommends it. It does not require it. And it doesn't say anywhere on the label that it's carcinogenic. So I don't think it was
What
stressed.
you heard, just to answer my question, it recommends it, correct?
Yes, it recommends it.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor, a brief redirect. Might I inquire as to how much time I have remaining before I begin?
Yes, you may. There we go.
You have 1 minute and 45 seconds remaining.
Thank you. Mr. Dr. Rogers, would you please just elaborate a bit more to the jury about why the recommendation label wasn't sufficient with what you had learned from your study?
Well, what I learned from my study is that many users of Drufo and many people are not given proper access to equipment like face masks. So I wasn't even sure if that level of protection was sufficient, but at the same time, the label only recommends that they wear a mask and long sleeves. It does not require it, and it does not state anywhere on the label that this product is carcinogenic. So it does not stress nearly enough how important it is to follow even these precautions.
Thank you, Dr. Rogers. Thank you, Your Honor. I have no further questions.
Plaintiff, you have any further witnesses?
No, Your Honor, the plaintiff rests.
Defense, please call your first witness.
Defense calls Blake Doncourt.
Mr. Doncourt, you've previously been sworn. Please proceed.
Good evening. Please state your full name and spell your last for the court.
Good evening. My name is Blake Doncourt. My last name is spelled Doncourt.
What is your occupation?
I am the Chief Executive Officer at Lush Fertilizer Incorporated.
Did you start Lush Fertilizer?
I did. I essentially built Lush from the ground up. It was a great expedition. And we've accomplished much. We sell commercial fertilizers to governments, businesses, and individuals. It essentially optimizes growth and production, and it's something we're extremely proud of.
Do you donate to any charities?
We do. We actually donate 10% of our profits to charities, specifically predicated on reducing the nitrogen footprint. Not only this, but we've started our own. And we've received many awards for this, including the Champions of the Earth Award and the prestigious SEAL Business Award. And also, we are proud to be environmental lobbyists and activists.
Do you know why you're here today?
Well, yes. The plaintiff is suing myself and my company, despite the fact that we had nothing to do with it, as all evidence would show.
Objection. Objection, Your Honor. Lack of personal knowledge as well as improper lay opinion.
Response?
Your Honor, I'm simply asking why Mr. Doncourt is here today, and he should know as he's been sitting in this courtroom.
May I respond, Your Honor?
Well, I'm going to sustain the objection to the extent that the answer went a good bit beyond the question. And that's not necessarily, again, a bad thing on direct, but I think you may have pushed over the line on that answer. So I'm going to sustain the objection as to the part of the answer that went in to his opinions regarding the validity of this lawsuit.
May I rephrase, Your Honor?
You may.
Are you aware of your accusation today?
Yes, I am aware of our accusations. My sympathies go out to Ms. Weirs. To my understanding, she was diagnosed in the early stages of development with non-Hodgkin's lymphoma, and I hear that's quite good. And I wish her Godspeed in recovering, but Lush Fertilizer is simply not responsible.
Objection, Your Honor. Improper lay opinion. Again, Mr. Doncourt cannot testify to whether or not Lush is responsible. That is what we are determining here at court.
Response?
Yes, this is to go against the motive that the plaintiff is trying to prove that they are responsible. And he is allowed to testify on this behalf.
May I
Reply?
I would be welcome to hear Mr. Doncourt's testimony on his personal feelings or his personal perception of the case, so long as that testimony does not reach into a definitive decision on this case, or testimony that Mr. Doncourt has no place to be making as a lay witness who lacks medical and scientific qualifications. He cannot say whether or not Drufo causes cancer, whether or not Lush is responsible, or any of these facts that have been stipulated.
The objection is sustained again as to this witness's expression of an opinion as to the validity of this lawsuit. That testimony, as with his prior testimony to that same effect, shall be stricken.
Yes, Your Honor, thank you.
Let's proceed.
Sorry. Moving on to a product in your fertilizer. What is Drufo?
Well, Drufo is essentially a bonding agent that's used in our product, and what it does is it increases the efficiency and productivity of fertilizer, as well as reduces the level of nitrogen. And actually, it's a step towards environmental activism because it doesn't have harmful products like arsenic or glyphosate like many other fertilizers do.
Did the EPA, the Environmental Protection Agency, ever make findings that Drufo was at all harmful for public use?
Oh, no, not at all. We are in 100% compliance.
Your Honor, this calls for hearsay, an out-of-court statement made by the EPA.
Response?
Your Honor, this is directly stated in Mr. Doncourt's witness statements that it made no findings, and that is why there was no need to put a warning label on the product.
Your Honor, may I respond?
Please reply.
Just the fact that it is in a witness statement does not make it not hearsay. It is still an out-of-court statement that is being offered for the truth of the matter asserted.
Response?
Your Honor, this is not being offered for the truth of the matter asserted. It is simply a fact that the EPA never made the findings and goes against the motive.
Your Honor.
Objection is overruled.
Thank you, Your Honor.
Are you aware of a study performed by the plaintiff's expert, Casey Rogers?
Yes, I am aware.
Do you believe that this study was reliable?
No, to my knowledge, not at all. If you even really want to call it.
Your Honor. This is improper lay opinion. Mr. Doncourt has not been qualified as a scientific expert and cannot attest under Rule 702 to the validity of a study.
Response, Your Honor.
You may.
Under Rule 701, Mr. Doncourt is allowed to give his opinion here because it is rationally based on the witness's perspective.
Response?
Your Honor, an opinion on a in-depth scientific study such as Dr. Rogers is one that requires specific knowledge that is required of an expert. Mr. Doncourt has no foundation for understanding the ins and outs, so to speak, of this scientific knowledge, and therefore he can attest to his personal feelings on the matter, but he cannot attest to whether or not the study is valid.
I would like counsel to lay some additional foundation as to the lay experience or knowledge or study or whatever that this witness has that qualifies him as a lay expert to comment on a scientific study. And I'll give you that opportunity if you want to take it.
Yes, Your Honor. Mr. Doncourt, did you create Drufo?
I did create Drufo. Yes, that is correct.
Are you aware of any studies dealing with any dangers related to Drufo?
No, not at all. As CEO of Lush Fertilizer, it is of my utmost priority to be responsible for managing and looking at many studies that have been postulated, including Dr. Rogers and in-house studies that we've conducted on our own.
Moving on to a former employee of yours, do you know Carson Durst?
Yes, I do know Carson Durst.
Did you give him a job at Lush?
Yes, I did in fact give Mr. Durst a job at Lush Fertilizer. I hired him in 2003 and he was terminated in 2006.
Did he quit or was he fired?
He was terminated. And quite frankly, Mr. Durst got extremely lazy and was receiving many poor performance reviews.
Objection, Your Honor. Improper character evidence.
Response?
Your Honor, this just goes to show the reasoning behind his termination, and it is not acting in accordance with his trait of laziness.
Reply.
Your Honor, under Rule 404A1, evidence of a person's character is not admissible to prove anything about that person's actions. I can't imagine why this is being offered if not to prove Mr. Durst's actions. And so if it's not being offered to prove any of that or not being used under Rule 405, this is improper.
Objection is overruled.
Thank you, Your Honor.
While working at Lush, did Mr. Durst sign a non-compete agreement?
Yes, Mr. Durst did in fact sign a non-compete agreement. That is correct.
And is this standard practice to have your employees sign the agreement?
Yes, absolutely.
Now let me ask you about Exhibit 4. That's the email Mr. Durst claims to have received from Jerry Langley.
Correct.
Have you ever seen that email before today?
No, not at all. And if it was so important, I believe Mr. Durst would have brought this directly to my attention.
Objection, Your Honor. Speculation.
Response?
Your Honor, this just proves that Mr. Durst never brought it directly to Mr. Doncourt's attention, and there was no email that Mr. Doncourt saw.
Objection is overruled. Please proceed.
Did Lush provide all of its emails to the plaintiff?
Yes, Lush did in fact provide all of its emails to the plaintiff, and what was found was no emails resembling anything close to Mr. Durst's alleged email in our email server.
If Mr. Durst had any concerns whatsoever about Truffaut, did he ever bring them to your attention?
No, not at all. And part of Mr. Durst's job was to bring this type of information to my attention. It was never done. And this is part of the reason why Mr. Durst was fired. They were clearly irresponsible.
Finally, Mr. Doncourt, do you believe you are responsible for Dakota Weir's emotional and physical distress?
No, I do not. And to my knowledge, the evidence indicates that that there is no causal link between Truffaut and any carcinogenic effects. However,
this is the opinion on the ultimate issue, and under Rule 704, Mr. Doncourt cannot testify to whether or not Truffaut causes cancer.
Response?
Your Honor, this is his own personal knowledge, and he can testify of his belief of his own personal product.
The problem I have is that the question you're asking is about his personal belief as to, one, it's an ultimate legal issue, and second, it calls for, in my view anyway, a great degree of scientific expertise. Now, if you would, I'll give you the opportunity to lay some foundation for your question, but otherwise I'll sustain the objection.
Yes, Your Honor. Thank you.
Mr. Doncourt, were you ever aware of Truffaut causing cancer?
no, not at all.
If you were aware, would you have taken the precautions necessary to avoid it causing cancer?
Yes, absolutely. As I've established earlier, I am the CEO of Lush Fertilizer. It is my job to be responsible for the studies at hand and to look at them and decide whether or not we ought to, whether or not, our product is safe. And from my knowledge, right, this was never established.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Hello and good evening. I assume it's all right for me to refer to you as Mr. Doncourt?
Yes, that is correct.
Thank you. Now, Mr. Doncourt, You consider yourself to be an environmental warrior.
Wouldn't necessarily use that terminology. We are hyper focused on the environment as we donate 10% of our profits to charities. But environmental warrior, I don't necessarily think I would use that term.
Mr. Doncourt, you care about the environment.
Absolutely.
And your work has been nominated for very public environmental awards.
Yes, of course.
And you managed to donate 10% of profits to the environment?
That is correct.
And you make these donations very public.
I would say so, yeah. I mean, our company prides ourselves in what we do for the environment. We have made tremendous strides environmentally.
Yes, Mr. Doncourt, and to that point, your products contain a chemical called Drufo, yes?
Yes, that is correct.
And Drufo is supposed to limit environmental impact.
Yes.
And you claim this chemical has little risk.
Yes.
Now let's talk about your company. You are the CEO of Lush Fertilizer?
That is correct.
Now, Lush did the regular preliminary tests on Drufo?
Right, that is correct.
And Mr. Doncourt, you heard Carson Durst's testimony today, correct?
Yes.
You heard Carson Durst testify to what a superior told him about keeping Drufo's risks in the walls.
That's what Mr. Durst claims.
You claim that you never would have put Drufo on the market if you thought it was carcinogenic.
Right, that is correct.
Now, Mr. Doncourt, you don't personally oversee testing. As CEO, you oversee the whole company.
Right. Well, I oversee everything, quite frankly. I oversee the studies, I oversee management, administration, and all of our proceedings therein.
Let me specify, Mr. Doncourt, you don't personally test the products.
No, I am not a scientist. I trust my toxicology department to conduct adequately all of the studies at hand that are necessary to market our product.
So you rely on your personnel to bring things to your attention?
Right, that is correct.
So you are given regular reports on what happens in your company?
Yes, again, as CEO, we always look at the reports, we look at the evidence at hand, we look at what's going on administratively, and that's something we've always done, as is standard practice in Lush Fertilizer.
Yes, and things happen all the time in your company that you aren't personally made aware of.
Well, I think that's a bit speculative. I don't know every little detail, but I'm aware with the big picture of what's going on in Lush Fertilizer.
Well, exactly, Mr. Doncourt. So if your personnel don't see fit to bring something to your attention, you don't know about it.
Sure, I would agree there.
Thank you, Mr. Doncourt. Now let's move on. You say there aren't any valid studies showing Drufo is dangerous.
Right, that is correct.
But there is a study from Dr. Casey Rogers.
Casey Rogers did in fact conduct a study.
Now you don't personally agree with this study?
No, I do not agree with any parameters of this for many reasons. One of the reasons being,
Thank you, Mr. Doncourt. And you don't mention any scientific education, Mr. Doncourt.
I'm not a scientist, no.
You do not mention experience as a researcher.
I'm not specifically focused on research necessarily. I oversee studies and the proceedings of my company, but.
So, Mr. Doncourt, to restate, you are not a scientist.
No, ma'am, I'm not a scientist.
Now, in your statement, you say that Drufo was below the threshold for immediate risk.
Right, that is correct. We are in within EPA and FDA standards, and we are 100% in compliance with the level of carcinogenicity, which is not statistically relevant whatsoever in terms of its substantial relationship with the safety and well-being of our customers.
So, Mr. Doncourt, what all that implies is that there was a risk, however small.
Right. I mean, risk is an interesting term. We have to look at it connotatively instead of the scientific denotation.
Mr. Doncourt, I am not asking for a philosophical in-depth discussion on risk.
Objection. Badger.
Is there an objection?
Yes, badgering the witness, Your Honor.
Response.
Yes, Your Honor, I can understand how it would seem that way. I was merely asking Mr. Doncourt to answer my question instead of an unrelated statement that I did not ask. And as this is my cross, the questions I am asking are of pertinence.
Well, let me caution the witness, please, to try to answer the questions on cross, yes or no, If you need to elaborate, do so briefly, but please try to keep it within the scope of the question. And if your counsel seems to want to have you elaborate, that's the function of the redirect process. So please try to answer yes or no if you can, and if you can't, answer as briefly as possible on cross-examination. Well, please proceed.
Your Honor, may I repeat the question?
You may.
Now, Mr. Doncourt, your previous statement implies that there was a risk, however small you may believe it to be.
Right, there was a statistically irrelevant risk. That is correct.
In your words. Now, you decided that the preliminaries were sufficient.
Right. I looked at the preliminaries and they were quite comprehensive as well as multivariable. So absolutely, I have no reason to believe that they weren't.
Well, to clarify, Mr. Doncourt, you did not pursue intensive testing.
Well, no, we did. I looked at my toxicology department and we've conducted many, actually 2 comprehensive studies that were multivariable and isolated Drufo specifically, analyzing its biomolecular and biochemical processes and determining and postulating that not only was there no causal link, but it was safe for our customers to use.
Well, Mr. Doncourt, one of the things that those tests found is that baking the fertilizer would eliminate all forms of risk, yes or no?
Statistically irrelevant risk, yes, that is correct.
And so you say that baking would have been unnecessarily expensive.
Yes, of course, as it was statistically irrelevant, of course.
Okay. So you knew that there was a small risk involved with Drufo.
Yes, as with every single effective pesticide, of course, there's always going to be some small risk.
Well, you knew that this risk was easily avoidable.
Well, not necessarily. I wouldn't say it's easily avoidable. I mean, it was not necessary. Why would a company dedicate baking Drufo that if it was not statistically relevant? I mean, we have to manage ourselves. We can't just be doing needless procedures.
Mr. Doncourt, you still didn't bake the products.
That is correct.
Despite the fact that your scientists told you baking the fertilizer would eliminate all forms of risk.
All of the risk at hand, ma'am, was statistically irrelevant. There was no need for us to bake Drufo. If we needed to, we absolutely would have.
Mr. Doncourt, this is a yes or no question. You did not bake the products, correct?
Right. I've already established that we did not bake Drufo.
Thank you, Mr. Doncourt. So in short, you chose your profits before eliminating risk?
No, I mean, I resent the notion that I chose profits over people. We did not do, I mean, we could have, ma'am, if I may elaborate briefly, we could afford it and we didn't because it was statistically irrelevant.
Mr. Doncourt, please, if your answer to the question is no, please simply say no.
Okay, I believe I just answered the question.
Thank you, Mr. Doncourt. Your Honor, I have no further questions for this witness at this time.
Redirect?
No, Your Honor.
Thank you. Defense, please call your next witness.
The defense calls Skylar Weirs.
Ms. Weirs, you've previously been sworn. Please proceed.
Good evening. Please state your name and spell your last for the court.
Yes, hi, my name is Skylar Weirs. That's W-E-I-R-S.
Ms. Weirs, are you related to the plaintiff?
Yes, I am. He's my twin brother, although we didn't get any of those psychic powers they always talk about in the movies.
What is your current occupation, Ms. Weirs?
If you ever see me in a coffee shop furiously typing on my computer, then you would know that I am an investigative journalist. I also maintain a second job as a server. Got to pay the bills.
What types of articles have you written as an investigative journalist?
Well, recently my supervisor asked me to write a series of articles on modern agritech. And as a result of the series, I wrote and published an article about Drufo.
What types of topics have you covered within that umbrella term of agritech?
Well, we cover a lot of things, mostly relating to pseudo-scientific mass hysteria that surrounds the agriculture industry.
Have any of the articles that you've written been published?
Yes, my article on Drufo was published in my magazine, or the magazine I work for.
What magazine do you work for?
Oh, well, I work for The Rationalist.
And what type of articles does The Rationalist typically publish?
At The Rationalist, we encourage people to ask the right questions about scientific issues. Basically, we try and mitigate hysteria or conspiracy. And if I can assure someone that a scientific product or development is safe, then it's a good day for me.
Do you have any specific experience researching and writing about blush fertilizer in relation to Drufo?
Yes, I do. For my series of articles, I spent a year researching documents and studies, mostly from the United States Department of Agriculture and the National Association of State Departments of Agriculture. I take information from all these sources and use them to write my articles.
So would you say you're well versed in all the relationships between Drufo and other sort of carcinogenic fertilizers?
Yes, absolutely.
Your Honor, we offer Skylar Weirs as an expert in agribusiness, specifically about the impacts of exposure to fertilizers, including Drufo, on humans and the environment.
I'm sorry, agribusiness and then what?
Specifically about the impacts of exposure to fertilizers, including Drufo, on humans and the environment.
Any response?
Your Honor, if I may conduct a brief voir dire.
You may.
Hello, Ms. Weirs. You have no experience working in the agribusiness, as you call it, industry, correct?
Well, no, I'm not a farmer or a researcher. I do write about the subject very often, though.
Right, and you lack a degree in agribusiness, correct?
Yes, I decided to forego college when my journalism career began to take off.
And you have never been to med school?
No, I'm not a doctor.
You don't have a degree in environmental sciences?
No, ma'am.
Do you have knowledge of agribusiness?
Oh, absolutely. As a result of my series of articles that I've been writing, I've done a heavy amount of research on several topics under that umbrella, including chemicals and Drufo.
Thank you, but you say it's a general knowledge, correct?
Yes, general historical knowledge. You don't necessarily need a degree for it, so I've done my research independently.
Thank you, Ms. Weirs. And for your research on agricultural technology and business, can you name any specific studies for me?
Scientific studies or examples of the agribusiness arena?
Can you name any names of studies? Perhaps links?
I can give an example of a company in the agribusiness that I've been studying if you'd like.
Ms. Weirs, can you name any authors of these studies?
No, not of scientific studies. I can tell you that they're from the National Department of Agriculture or the National Association of State Departments of Agriculture. This is where I get most of my information.
But you cannot name any specifics on where your other research comes from, can you?
My other research on the topics for my articles? No, I mostly draw from these nationally verified sources.
Right, but you do say that you get a lot of your information from companies, correct?
Yes, studies that companies have done or studies that the State Department has done. I used all this information for my research.
Thank you, Ms. Weirs. The plaintiff objects to Skylar Weirs testifying as an expert witness regarding agribusiness and the environmental and physical impacts of fertilizers in humans. Ms. Weirs has no medical degree, and according to Rule 702, a witness may be tendered as an expert if their knowledge in the field is classified as scientific, technical, or specialized. Ms. Weirs does meet this criteria. However, Judge Staub's pretrial ruling required that the witness provided an understandable explanation, including the amount of time spent researching these qualified companies. And Ms. Weirs has testified that she cannot name any specific companies and therefore cannot testify as an expert in the area of agribusiness, including the health implications.
Response?
Yes, Your Honor. Pursuant to Rule 702 and the court's pretrial ruling of November 1st, a witness is qualified as an expert by knowledge, skill, experience, training, or education. Ms. Weirs displays the proper knowledge and experience due to her career centered around agritech and her in-depth knowledge on Drufo. Although Ms. Weirs does not maintain a degree in the related topics, she completes the required criteria. Regarding the pretrial motion, Ms. Weirs has detailed that she studied Drufo for less than a year. That is a specific amount of time allotted for her research, and therefore she does meet all the required criteria.
Reply?
Your Honor, I have no objection to the agribusiness. However, I do have an objection to the health implications of fertilizer. Ms. Weirs has no medical degree and has spent no time. Ms. Weirs has elicited that she spent no time researching the health implications of fertilizer and therefore cannot testify.
Okay. I will find that this witness is qualified under the terms of the pre-hearing order by Judge Staub, which states that the offer of proof is that this witness spent considerable time researching agritech companies by reviewing publications written by those companies, research studies referenced in those publications, and information maintained by the USDA and the NASDA. Those criteria have been met by the testimony of this witness, and under the pre-hearing ruling, this witness shall be deemed an expert in the agritech business. And as to the other aspect of the offer of this witness as an expert, impacts of fertilizer, generally impacts of fertilizers on humans, for now, I will treat that as being an adjunct or a component of agritech. Seems to me it is, but if in the context of a particular specific question, counsel wishes to object to the question as being beyond the scope of this expert's qualifications or this expert's qualification, singular, as an expert, you may raise that objection at that time in that context.
Thank you.
But for right now, this witness is deemed an expert who can testify to opinion evidence pursuant to Rule 702. Please proceed.
Ms. Weirs, you said you reached some opinions in this case. What are those opinions?
My first opinion today is that my brother's diagnosis was the responsibility of really his workplace, Haven Landscaping. And this is because at his workplace, he was exposed to a whole slew of chemical products, and Haven did not require him to use proper protection. Secondly, I will say, although there is always an inherent risk to fertilization products, Drufo is actually designed to keep its users safer than products of Lush Fertilizer's competitors. So it's much safer for human use because it doesn't contain chemicals such as glyphosate or arsenic.
Now, Ms. Weirs, your first opinion was that Haven Landscaping is involved in Dakota's diagnosis. What's the basis for that opinion?
As a result of my brother's job, he could have been working with a whole host of chemical products, all of which are known to at times be dangerous. And he was exposed to these products without a requirement of, per se, a mask or long sleeves or pants. And this unduly exposed him to chemicals that could be deemed harmful.
Now, in your expert opinion, did Haven take the steps that they should have to protect their employees?
No, absolutely not. And I would say that this is an issue of poor training.
Objection, Your Honor. This is outside of the scope, this witness's expertise.
Response?
Yes, Your Honor. With Mrs. Weir's advanced history in researching and writing about the dangers of Drufo and harmful fertilizers, she's well versed in the precautions that need to be taken. And therefore, comparing the testimony today that she's heard in court about the steps that Haven Landscaping took or failed to take, she's allowed to make that conclusion based off of her research.
Response, Your Honor.
Reply?
I believe Ms. Weirs has never done any research on Haven Landscaping, the company themselves. Therefore, she cannot make any testimony as to Haven Landscaping's procedures and how they handle their own employees.
The objection is overruled. You may go into those issues on cross-examination if you wish, but I deem these questions to be fairly within the concept of agritech and agribusiness within the scope of this expert's expertise. Please proceed.
So, Ms. Weirs, I'm going to re-ask my question. Based off of your expertise, did Haven take the steps that needed to be taken to protect your brother and its other employees?
No, frankly, allowing my brother to use these type of products that are unstudied, we don't even know what products could have been used, and they could have been a lot more dangerous than Drufo, not even focusing on trying to mitigate the risks of human exposure like Lush Fertilizer has. And in this case, Haven allowed my brother to work with these products without proper protection.
Now, your second opinion was that fertilizers may be harmful to the environment and to humans. Can you talk a little bit more about that?
Yes. Well, the problem with most fertilizers and pesticide products today is that they're soaked in these chemicals like nitrogen, arsenic, and glyphosate. The two of latter, which are known to be carcinogens, while glyphosate is a possible known carcinogen. And these chemicals can seep into waterways, they seep into the ground, and workers are exposed to them, which can cause harmful effects.
So how does Drufo fit into this picture?
Well, I think a good metaphor for Drufo as a chemical is kind of like getting into a car. Obviously, every time you go out for a drive, there's some risk that you're going to see. But you can take precautionary measures like wearing a seatbelt or driving a car that's designed to be safer. Now, this is exactly the way that Drufo was developed. Obviously, there's always some risk to any fertilizer products that you're using. But Drufo, because it doesn't contain glyphosate or arsenic, is actually designed to be safer for users to apply. And furthermore, either way, you can take the precaution of wearing a mask or long sleeve clothing.
Objection, Your Honor. Narrative.
Response?
Yes, Your Honor. To repeat my question, I said, how does Drufo fit into this picture? As Ms. Weirs had previously been detailing the dangers of fertilizers, everything that Ms. Weirs has stated is going back to how Drufo relates to fertilizer, how it protects the users from fertilizer. There's been nothing that has gone outside of the scope of this question.
The objection as to a narrative answer is overruled. Please proceed.
So, Ms. Weirs, did Drufo endanger your brother?
Well, no, I wouldn't say any more than any other product would, probably even less, because instead, Drufo is designed to keep users safer than other products.
And do you believe that your brother is rightfully suing Lush Fertilizer?
No, absolutely not. To be honest, my opinions here today are because I believe in the truth. And what I believe in the case of my is that he's just going after the wrong company. It was Haven that allowed him to use a whole host of products without protection. And Drufo wouldn't be any more responsible than these other products, which aren't even mentioned in the case today. And this is a very concerning topic to a person who believes in finding the truth of the matter in science.
Thank you, Ms. Weirs. No further questions.
Cross-examination?
Yes, Your Honor. May I proceed?
Please proceed.
Good afternoon, Ms. Weirs. I'd like to talk a bit more about the work that you do. You write for The Rationalist, correct?
Yes, that's correct. I'm a freelance writer and I write for the magazine.
Right, and it is a science advocacy magazine to promote scientific skepticism, correct?
Yes, and to prevent mass hysteria about scientific developments.
So it is your job to question scientists?
Yes, but mostly it's my job to discourage any hysteria the general public might have over a particular scientific topic or product.
Thank you, Ms. Weirs. And you've been in this profession for a couple of years, correct?
Yes, I've been writing since I decided to forego college.
Right, and for The Rationalist, you publish articles along the lines of disputing agricultural technology, including Drufo.
Yes, I question with my articles the causal link between Drufo and cancer.
Ms. Weirs, you dispute a claim that Drufo causes non-Hodgkin lymphoma.
Yes, I do, and I challenge the perception that Drufo would be any more dangerous than other products that people might be using.
Ms. Weirs, do you name any of these specific products?
No, but I can tell you that they would have to include other pesticides. Drufo is actually an effective pesticide, whereas other products don't have this advantage. This is why it's such a revolution in the industry.
Thank you, Ms. Weirs. Yes or no, you say that there are indeed risks from modern agricultural products.
Yes, there's always some risk.
Thank you. And you say that pesticides are by definition poison.
Well, poison for plants. This means that humans can also experience some harmful effects, but it wouldn't kill you to use it. Specifically, one-time use, that's what I mean.
You say that every commercial pesticide has well-known carcinogens, such as nitrates, correct?
Yes, nitrate is one that is very common in the fertilizer arena.
And do you believe that carcinogens are effective in plants?
I'm not sure I understand the question.
I'll move on. Ms. Weirs, do you consider Drufo a modern agricultural product?
Yes, and I think it's a revolutionary product.
Yet you claim that Drufo is not poison.
Well, I will say Drufo still does contain an amount of nitrogen, and this is used to poison weeds. There is still some risk because it contains nitrogen, but far less than other products.
Ms. Weirs, but nitrogen is known to contribute to various types of cancer, yes or no?
Yes, that's correct.
Yet you cannot find any information on whether Drufo specifically causes cancer, correct?
Yes, the results of the causation between cancer are inconclusive at best, but there is no study that proves a causal link between Drufo as a product and cancer.
Thank you, Ms. Weirs, but you cannot find a single study claiming that it does not cause cancer.
Well, I can't find any studies that prove a causal link, so yes, I assume the opposite would be true.
Thank you, Ms. Weirs. And you were never really close with your sibling, correct?
Well, we don't.
Relevant?
Response?
I believe that Ms. Weirs has testified on direct examination as her relationship with her sibling. Therefore, it opened the door for me to ask these questions on cross.
Reply?
Ms. Weirs merely testified to being the sibling of Dakota Weirs. This testimony is going into the territory of the specifics of the relationship, which is going to the territory of unfair prejudice. Therefore, I don't see how the relationship is relevant to a case based on Drufo.
response?
The
Your Honor?
objection is overruled as a kind of an introductory question. I think this is fair cross-examination, and I can see some relevance of where this line of questioning might be going. If it doesn't go where I think it's going to go, you may renew your objection on relevance. So please proceed.
Thank you, Your Honor. And you were never really close with your sibling, correct?
Well, as I was saying, we don't have that typical twin relationship like you see in TV shows or anything, but I love him and he's family.
That's enough. He doesn't support your career, correct? Yes or no?
I'm not sure how he feels about my career. I know my parents weren't very happy about it.
Ms. Weirs, your sibling testifying today here has cancer, correct?
Yes, non-Hodgkin's.
And those medical bills are extremely expensive.
Yes, I am aware that the medical bills have quite a toll on the family.
Right, and you don't make much money as an investigative journalist, do you?
No, that's why I'm forced to maintain my second job.
Right, and you're worried about the money expenses compared to you and your sibling, correct?
Yes, I don't make as much money as a lawyer per se, so I am worried about paying the bills.
Thank you, Ms. Weirs. I have no further questions for this witness at this time.
Any redirect?
Briefly, Your Honor.
Please proceed.
So do all fertilizers have nitrogen in them?
No, not necessarily. Most contain nitrogen because of the environmental needs that need to go into a fertilizer, but not all of them necessarily.
And does Drufo increase or decrease the dangers of nitrogen in lush fertilizer?
Well, it actually decreases the dangers. You don't need to apply Drufo as much. And because Drufo contains nitrogen, this means less nitrogen being used by people applying the product and less nitrogen contaminating the environment. So it really lessens the effects of the nitrogen.
And what does this mean consequentially for its carcinogenity?
This means that any carcinogen effect that would be present is far lesser than other products.
Thank you. No further questions, Your Honor.
Thank you. Defense, call your next witness, please.
The defense calls Dr. Devin Williams.
Dr. Williams, you've been previously sworn. Please proceed.
Good afternoon, Dr. Williams. Can you please state and spell your name for the record?
Yes, I am Dr. Devin Williams, spelled Williams.
Dr. Williams, were you asked by the defense to give some opinions on this case?
Yes, I was.
Did you reach some opinions?
Yes, I have.
Before we get to those opinions, let's talk about your background. Can you please tell the jury about your education?
Yes, I got my BS, MS, and PhD all at Colorado State University in Fort Collins. And I also got my post-PhD specialization education in pharmacotoxicology at the University of Utah.
Do you hold any certifications or accreditations?
Yes, I hold accreditations across several different states.
What are they?
I have accreditations in, give me a second, there are actually quite a few. There's one in Colorado, Utah, Wyoming, and New Mexico.
Are you on the faculty of any academic institution?
Yes, I'm currently an assistant professor at the University of New Mexico College of Pharmacy.
What courses do you teach there?
I teach wonderful courses. One's in forensic toxicology, another in principles of forensic toxicology, and the third is my personal favorite. It's toxicology of environmental and occupational chemicals. That one's really interesting.
Before you worked for Lush, have you had any other employment in toxicology?
Yes, I also, for a brief stint, worked at the Larimer County Office of the Chief Medical Examiner Toxicologist.
How long have you worked for Lush?
I've worked at Lush for, let's see here, just about over a decade now.
What are your duties there?
Well, I oversee the development in research labs, and I also have the job of overseeing largely the environmental effects of the products that are produced at Lush Fertilizer.
As part of your experience and training, do you have to reach conclusions about the effects of potentially toxic chemicals?
Yes, that I am trained to understand how chemicals will affect the average person.
Do those conclusions also apply to the environment?
Yes, on a daily basis.
The defense offers Dr. Williams as an expert in toxicology and the effect of DRUFO on humans and the environment.
Toxicology and the effect of DRUFO, excuse me, on the environment
And humans.
and humans. Okay. Any objection?
No objections at this time, Your Honor.
All right. This witness will be deemed qualified as an expert in the requested fields and may testify pursuant to Rule 702 through opinion evidence. Please proceed.
Dr. Williams, you said you reached some opinions. What are they?
Yes, I reached the opinion that there is absolutely no valid evidence, which is to say that exposure to DRUFO causes non-Hodgkin lymphoma.
What did you do to reach this opinion?
Well, we at Lush Fertilizer conducted several research experiments, but we basically relied on statistics and scientific math.
Did you have any development in or any involvement with the development of DRUFO?
Yes, I originally joined Lush Fertilizer as a technician through the first 2 years of development of DRUFO. So I've been around since basically its infancy.
Do you know why DRUFO was created?
Yes, DRUFO was created to essentially address the influential and substantial negative effects that comes with almost every other fertilizer.
Can you please explain to the jury the issues with nitrogen and fertilizers?
Yes, essentially every fertilizer, including DRUFO fertilizer, produces nitrogen when they are used. Essentially, when the fertilizer is applied with other fertilizers, it's a significantly larger sum. It is then, over time, consumed by bacteria. A product of that consumption is nitrates. And an excess of those nitrates is essentially a very dangerous thing, especially if it is introduced to local water sources, which they tend to be through water runoff, because those can produce algae blooms, and those are proven to be significantly dangerous to human beings.
Where does DRUFO fit into this nitrogen problem?
Well, DRUFO being a bonding agent, it acts essentially like a glue. And what it allows for our fertilizers is that they aren't used as often plentifully. They glue the fertilizer to the product. And because of that, there is less nitrogen produced and less of those negative effects that are felt by the environment and human beings.
Is there still nitrogen in DRUFO?
Yes, there is. As I mentioned before, every fertilizer is going to have a production of some nitrogen, but the presence of DRUFO limits it to such a great extent.
Has the U.S. Department of Agriculture approved the use of DRUFO?
Yeah, or to not be allowed.
Objection, hearsay.
Response?
Your Honor, first off, Dr. Williams has been in this room listening to previous testimony, and it has been previously testified that the U.S. Department of Agriculture has approved the use of DRUFO. But then second, Dr. Devin Williams is testifying off of his own personal knowledge. And as he is an expert in regarding DRUFO and the people in the environment, he would have the knowledge to testify that the U.S. Department of Agriculture has approved the use of DRUFO.
Reply.
Yes, Your Honor. Regardless of the fact that this has been brought up previously, it is still an out-of-court statement offered to prove the truth of the matter asserted. And I believe that the stipulation that opposing counsel is bringing up is that an expert may rely on things they've heard outside of court to make an opinion. But I have yet to hear what opinion this hearsay is helping Mr. or Dr. Williams make. So if this hearsay is to be used, I believe there might be more foundation need to be laid so that we can see what opinion the hearsay is going to.
Objection is overruled. Proceed.
Dr. Williams, you said you reached the opinion that Drupal likely did not cause Dakota Weir's non-Hodgkin lymphoma. What is the basis of that opinion?
Well, the basis of that opinion, to put it very bluntly, is the statistical increase that we found in our own research studies that just wasn't present. In our own studies, we tested two basic groups. One group was with people with similar environments to the second group, but the major difference and the only variable difference was that they used Drufo fertilizer. The second group was very similar to the first in their environments outside of the fertilizer, but they used fertilizers that weren't Drufo. And what we wanted to monitor was if there was any statistical increase between the two groups in which had a higher case of getting non-Hodgkin lymphoma. Between the two groups.
Your Honor, objection, I believe this is outside of the case materials.
Okay. Are you basing this on the extrapolation concept?
Yes, Your Honor. I don't believe Devin Williams' witness statement describes specific groups and what groups went into testing the Drufo at Lush Fertilizer.
Response?
Your Honor, we can pull up the witness statement if you wish.
Well, if you need to, if it is in the witness statement, it would be incumbent on you to please show that to us.
Yes, Your Honor. Are we allowed to share our screen?
With the witness statement?
Yes.
Yes, please do so.
Oh, okay. Specifically look at lines 81 through 82, where we specifically speak on answering the question through statistics. That's what Dr. Devin Williams was specifically talking to. Specifically, he was talking about when you take like a group of people who have used fertilizers with Drupal and comparing it to the incident rate for people who use different types of fertilizers. And that's where we specifically get into that's where his testimony was leading into the randomness element when you don't control the variables. That is specifically what Dr. Williams was testifying to.
May I respond, Your Honor?
You may.
I may have misheard Dr. Williams' testimony, but I believe Dr. Williams was trying to describe what happened in the testing at Lush Fertilizer. And this part of the statement is a response to Dr. Rogers' study and does talk about statistics of Drufo, but not specifically the testing at Lush Fertilizer. So I would ask that any of the responses that had to do with testing at Lush Fertilizer be struck, as this part of the statement, or his witness statement, is only about statistics and how statistics relate to Dr. Rogers' study and Drufo, but not specifically the testing that happened at Lush Fertilizer and any groups that were used at Lush Fertilizer.
May I respond, Your Honor?
Please.
When talking about Dr. Rogers' study, Dr. Williams is making a comparison. So that's where we gain the understanding of the different types of studies that we're conducting at Lush compared to Dr. Rogers' study. And that's why that piece of the witness statement is relevant to what we're talking about.
Sorry, Your Honor.
I'm gonna overrule the objection. I think the mention in the statement, in the witness statement, is sufficiently broad to cover this line of questioning. So overruled. Please proceed.
Dr. Rogers, going back, do you need me to ask the last question?
No, I'm fine. I can just explain it a little bit more concisely. To put it a little bit more simply, we found that through our own research and with the variables between Drufo fertilizer and other fertilizers, that we found no statistical increase in Drufo fertilizers of getting non-Hodgkin lymphoma. That isn't to say that in our performance groups that people in that group didn't get non-Hodgkin lymphoma. It's just to say that between the two groups, comparing it to other fertilizers, it was almost comparable. Because we can't say, well, at least with non-Hodgkin lymphoma, a cancer which is purely environmental, we can say that people are going to get non-Hodgkin lymphoma regardless in exposure to specific things. That's why we did the comparison between fertilizers.
Dr. Rogers, is that why you're comparing users of Drufo to users of other fertilizers and not just to non-users?
Yes, it was to help us limit our variables. As I mentioned before, non-Hodgkin lymphoma is a cancer which is gotten through environment. So there are several other parameters if we didn't keep the variables to the bare minimum, which could have affected our results. So by limiting it to fertilizer users and with people with similar environments, we were able to limit ourselves so that we could get a very clear conclusion.
Dr. Rogers, did you review a study performed by Dr. Casey Rogers?
Yes, I sadly did.
Do you have an opinion on the validity of that study?
My opinion of, I even hazard to call it a study, is that it is completely invalid.
What do you find wrong with Dr. Rogers' procedures?
There is so much that is incredibly wrong, but to try and keep this moving, I'll keep it simple. The variables that I mentioned before with our research that made it so, well, reliable are completely missing. They tout, which is completely a instrumental flaw in their research, as something to be proud of, that they have people of completely different environments with only one thing in common, that being Drufo. Let me remind you that non-Hodgkin lymphoma is a cancer which is gotten through environment. With so many variables being present, there is nothing that they can say with any substantial reasoning that Drufo is the only reason that those people got non-Hodgkin lymphoma. That is why our research is more superior. And that's only one reason. Another reason is that it hasn't been published in the scientific journal, nor has it been publicly replicated. My own research stands in complete contradiction with their findings. So from my perspective as a scientist and someone who's been in this field for more than a decade, it is very easy to see that this research is completely invalid.
Just to clarify, Dr. Williams, do your findings agree with Dr. Rogers' study?
Not at all. They are in complete contradiction with each other.
In conclusion, do you believe that there is any valid evidence that Drufo causes non-Hodgkin lymphoma?
I believe that there is absolutely no valid evidence which could even move towards the idea that exposure to Drufo causes non-Hodgkin lymphoma.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good evening, Dr. Williams. I'd just like to start off by discussing your connection to Lush Fertilizer. You've stated that you've been working for the company for about 10 years, yes?
Yes.
And you've been promoted to a top-tier position at the company.
Yes.
And you would say you're very comfortable in your position at Lush.
Well, personally, I wouldn't say comfortable. In my own line of work, I wouldn't anything I do is comfortable, but I'm pretty happy with where I am.
Thank you, Dr. Williams. Now, you've admitted in your witness statement that you're prejudiced in favor of Lush and against Mr. Weirs.
Well, prejudiced in the place that I want to support the affirmative action in the proof that there is no proof to say that exposure to Drufo causes non-Hodgkin lymphoma.
And Dr. Williams, in your statement, you admit that you have a financial bias in the outcome of the case, yes?
I did admit that, but if you're trying to say that I'm being paid for my opinion today, that is not the case.
Dr. Williams, would you agree that bias means to favor one side over another?
If we're going purely off of the definitional standpoint, I would say that. But in this case specifically, I wouldn't say so with financial bias.
Dr. Williams, I'm sorry, but that was a yes or no question. Would you agree in whatever case that bias means to favor one side over another?
I'd say it depends, but if I'm forced to give a yes or no answer, I will give a yes.
Thank you, Dr. Williams. Now, switching topics slightly, you mentioned several times in your statement how beneficial DRUFO is for the environment.
Yes, I did in fact say that.
You said you were sad that the jury cannot weigh the benefits of DRUFO to the environment in this case.
Yes,
And yes or no, in fact, Lush is currently looking to place fertilizers containing DRUFO into the EU.
yes,
And you said that if this case comes out in favor of the plaintiff, that would create a whole host of bureaucratic roadblocks with the EU.
yes. Any form of wrong information would definitely harm our effects in getting that across.
Now, Dr. Williams, there's a copy of your CV in the case today, is that right?
That is correct.
And would you recognize this CV if it was shown to you?
I would.
Would you take a look at Exhibit 9 for me, please?
Yes, give me a moment.
Would you say that's a fair and accurate copy of your CV?
Yes, I would.
Your Honor, I now move to admit Exhibit 9 into evidence.
Any objection?
Yes, Your Honor, we object under accumulation under Rule 403. If there's anything specific that the plaintiff wishes to ask Dr. Williams about, they can just ask them about it. They don't need a piece of evidence to do that.
Response?
Your Honor, I would like to ask Dr. Williams about the specifics of what is said on his CV. I'm happy to ask it without the document in evidence, but I believe pursuant to the 1000s in the rules of evidence in 1002, a requirement of the document is required for someone to testify to what is in it.
Objection is overruled. Exhibit 9 is accepted into evidence for all purposes.
Thank you. And timekeeper, I don't need you to pull that up. Or you can if you would like, no worries. Now, Dr. Williams, nowhere on your CV does it specify that you've previously worked with DRUFO. Yes or no?
I guess it does not say that on my CV.
And in your witness statement, you just mentioned the statistics of DRUFO. Is that right?
Yes, I did.
And in your witness statement, you never have the words Lush's testing, do you?
Probably not in those exact words, yes.
You never provide specific examples of data from tests that Lush conducted, yes or no?
No, but I did provide the results.
You never mentioned that baking DRUFO would eliminate all risk.
Well, that's not within my witness statement, but if you would like me to answer on that, I could.
No, thank you, Dr. Williams. And you don't cite any studies done outside of Lush fertilizer.
Well, I did cite Casey Rogers' research and how it's in complete contradiction to my own.
Let me clarify, you don't cite any studies that build foundation for your studies outside of Lush fertilizer.
No.
And you mentioned that Dr. Rogers' study hasn't been peer reviewed or replicated, is that right?
That is correct.
But you never mentioned that Lush fertilizer studies were peer reviewed, do you?
I oversee the research and development labs. That would insinuate that I am overseeing several.
Dr. Rogers, this is just a yes or no question. You never mentioned in your witness statement that Lush fertilizer studies were peer reviewed.
And I'm trying to tell you that I mentioned in my witness statement that I oversee the research and development labs, and that would insinuate multiple testing.
They were never peer reviewed by anyone outside of Lush fertilizer.
Outside of Lush fertilizer, no.
And they were never replicated by anyone outside of Lush fertilizer.
Yes, my own research is in contradiction with, as I mentioned before, Rogers.
They were never replicated to a result that was the same as yours outside of Lush fertilizer.
Not to my knowledge.
And Dr. Williams, the studies you conducted were done in 2003 before you released the product to the public. Is that right?
Yes.
And you never mention any studies done since then, do you?
I can't say that I do.
Thank you, Your Honor. Thank you, Dr. Williams. I have no further questions.
Any redirect?
Just a brief redirect, Your Honor.
Please proceed.
Dr. Williams, you did say that you teach at the University of New Mexico, correct?
That is correct.
Do they compensate you for that?
Yes, I am paid for my teaching.
Are you solely dependent on Lush fertilizer for your income?
No.
Let's move on to DRUFO specifically. You work for Lush fertilizer, correct?
That is correct.
And you have conducted numerous studies on their behalf, correct?
Yes.
And And Dr. Rogers, do you do this research with a team?
Yes, as I mentioned before, I oversee the the research and development labs. So I am working with other people.
Has any of your evidence proven a causal link between Drufo and non-Hodgkin lymphoma?
Absolutely none of it.
No further questions, Your Honor.
Okay, does the defense have any further witnesses?
Yeah, the defense rests, Your Honor.
Plaintiff, are you ready to proceed with closing argument?
Your Honor, might I request a brief minute to reset my space so that I may stand to give closing argument?
1 minute.
Thank you, Your Honor. I will be right back. All right, Your Honor, I am ready to proceed whenever you are ready for me to proceed.
Please proceed.
Thank you. Lush Fertilizer steals lives. They've stolen the life of Dakota Weirs, and they will continue to steal lives in pursuit of their green future. But for Lush, green isn't natural. Lush's green is money. Lush's green is profits over people. And Mr. Weirs is currently facing the consequence of those profits. Debilitating disease. Of course, members of the jury, you cannot base your decisions on sympathy. Pursuant to jury instruction number 1, we, the plaintiff, have the burden of proof today, and we must prove our case by a preponderance of the evidence. Remember, this simply means to prove something is more probably true than not. Today, we were tasked with proving the negligence of Lush Fertilizer when they allowed their product, Drufo, to harm Mr. Dakota Weirs. We need to show you this negligence by proving that one, Lush Fertilizer manufactured Drufo. 2, they failed to reasonably prevent risk to those using the product. 3, Dakota Weirs used the product in that expected manner. And 4, that Mr. Weirs has damages caused by Drufo. Now let's just walk through these elements from jury instruction number 2, one at a time. Number 1, I believe there is no dispute as to the fact that Lush Fertilizer created Drufo. Now, number 2, the defense would have you believe that Lush completed all necessary testing. However, none of their witnesses can actually speak to this process. Blake Doncourt may be the CEO, but he is not a scientist. Skylar Weirs received their information from the internet and never worked with Drufo themselves. And Dr. Devin Williams, the toxicologist for Lush Fertilizer, despite mentioning statistics, never describes any of the testing process and never cites any specific studies. Thankfully, we had Carson Durst in court today, and he told you that there was initial testing, a concerned email, a second round of testing, and the following concern that Drufo could be related to cancers, such as non-Hodgkin's lymphoma. He shared with you that the Lush team was told to keep this concern within the walls. And after that, no more testing occurred, and a report of Drufo's safety was drawn up. And the best part, this report actually gave a suggestion for how to mitigate the danger, to bake the Drufo. But as you heard Mr. Blake Doncourt, the non-scientist, say on cross-examination, baking the Drufo would have been unnecessarily expensive. So Lush ignored their own advice. They put their profits over people. And not just that, they failed to warn those using Drufo as required by jury instruction number 3. You have seen Exhibit 1, the user recommendation label, and you have heard Dr. Rogers explain that a general fertilizer label giving general fertilizer recommendations does not sufficiently warn users of the specific effects of Drufo. Now, number 3, we can all agree that Dakota Weirs used products with Drufo, but the defense would have you believe that he didn't use them in the expected manner. However, if Lush failed to properly test their products and failed to warn their users, then there can be no expected manner in which Drufo was safe to use. Number 4, Drufo causes cancer. I'd like you all to remember that Dr. Rogers is the only witness in trial today who includes a Drufo-specific study in her statement. Today, she explained that Mr. Weirs' lymphoma is more probably than not a product of his exposure to Drufo, citing specific evidence from her study. And of course, let us not forget the damages themselves. Living is not the same as surviving. And right now, Dakota Weirs is only surviving, day by day, watching his future crumble before his eyes. No, he may not know exactly what that future entails, but he knows it will never be the same. Today, the plaintiff has proven all 4 elements of negligence, and in accordance with jury instruction number 2, you must therefore find Lush Fertilizer liable for that negligence. We ask that Mr. Weirs be compensated for his pain and lost future in the amount of $21.9 million. That is $1,000 a day for the 60 years that would have been his life. Members of the jury, don't allow Lush Fertilizer to escape the consequences of putting their profits over people. Thank you.
Defense, your closing argument, please.
Yes, Your Honor. Ladies and gentlemen, thank you for your time and attention. Plaintiff just tried to convince you that this case is about putting profits over people, but it's not. This is a case of a young man's cynical search for a deep pocket defendant. It is undisputed in this case that Dakota Weirs has non-Hodgkin's lymphoma and that he is suffering, but emotion is not evidence. While working at Haven Landscaping, Mr. Weirs ignored the safety precautions listed on Lush Fertilizer. He disregarded the Lush label that told him to wear a mask and cover exposed skin. This directly relates to jury instruction number 8, which explains that the plaintiff is at fault if he failed to do something that reasonably careful people would do under the same or similar circumstances. So the question becomes, would a reasonably careful person wear a face mask or a long sleeve shirt when working around harsh chemicals for hours on end every day? Yes, a reasonably careful person would. In order for Lush Fertilizer to be negligent, the plaintiff must prove that Mr. Weirs was one of the people that the defendant should reasonably have expected to use their product. Lush Fertilizer expected trained landscapers and agricultural workers to use their product with the sufficient personal protective equipment, not a 14-year-old boy without safety gear. I want to remind you of jury instruction number 3, which states that plaintiff must prove that Lush Fertilizer knew Drufo was potentially harmful and did not take reasonable care to warn the user of risk of harm or injury. Now, Dr. Devin Williams, head of Lush Research and Development Labs, testified that he led thorough investigations into Drufo and found that Drufo does not have an elevated risk of causing non-Hodgkin's lymphoma compared to other fertilizers. Because Lush found no potential risk to users, there was no need to label their product with a warning, as there was nothing to warn the user of. Carson Durst claims that he took part in a study that proved a causal link between Drufo and cancer. However, the only proof of this study ever existing is in Mr. Durst's testimony. There's absolutely no record of this study in Blake Duncourt's email, as he allowed the plaintiff to search through. Without a paper trail, the plaintiff cannot prevail. The only evidence of Drufo having a causal link to cancer is found in one study done by Casey Rogers. This study has never been published in a scientific journal, didn't follow reliable scientific protocols, didn't compare users of Drufo to users of other fertilizers, and was never peer-reviewed or replicated. Dr. Rogers didn't review Haven Landscaping employment records and therefore doesn't know Mr. Weir's level of exposure, so we cannot compare the two. Profits over people. Defense claims that Blake Duncourt chose not to bake because he would lose 6% of all profits. Why would Mr. Duncourt risk lives and his company for 6% of all profits when he was in the position to donate 10% of all profits to a charity? Let's take a look back at jury instruction number 10, which states that any finding you make must be based on probabilities, not possibilities. The plaintiff can only tell you it's a possibility that Lush Fertilizer caused Dakota Weir's cancer because they don't know the other fertilizers he was exposed to while working at Haven Landscaping. Even Dr. Rogers testified today that other chemicals and products could have caused Mr. Weir's cancer. Haven Landscaping should be held accountable for its negligence and improper work conditions. Living is not the same as surviving. No, it's not. And that is the fault of Haven Landscaping, putting harsh fertilizers and landscaping chemicals into the hands of 14-year-old Dakota Weirs. Lush fertilizer has been studied. We know it's not as dangerous as the host of other products that Haven allowed Mr. Weirs to use. Those products haven't been studied. Mr. Weirs' managers at Haven did not fulfill their responsibility to protect their employees because they made no effort to enforce safety precautions. But why sue a small landscaping company when you could sue one of the most successful fertilizer companies in the nation? Haven Landscaping should be grateful their pockets weren't deep enough for Dakota Weirs, or they may be on the other side of this trial. Ladies and gentlemen, Haven Landscaping may have failed their responsibility to protect Dakota Weirs, but it's not too late for you to fulfill your responsibility. Thank you.
Does plaintiff wish an opportunity for a rebuttal?
Yes, Your Honor. Before I proceed, may I inquire as to how much time I have remaining?
You may.
You have 35 seconds remaining.
Thank you. Members of the jury, the defense claims that Dakota is looking for the deepest pockets. But I ask you, where else would Dakota look? The defense points to Haven. But let me ask, is it Haven's responsibility to test their products? No. Is it Haven's responsibility to mitigate the danger of Lush Fertilizer's products? No. If the warning label wasn't sufficient for Dakota to know to follow it, then it wasn't sufficient for Haven to enforce. The defense told you to look not at emotions. We agree the very same. Look at the facts from Dr. Rogers' study and the facts you didn't hear.
Stop. Stop.
Thank you.
Okay, that concludes the evidentiary hearing. And if this were a live presentation at this point, I would ask the gallery to please stand and give a round of applause to the students who just made this excellent presentation, both sides. And I just don't know how to do that by Zoom. And I would also, if it were live, after that, I would ask the students to stand and turn around toward the gallery and give the gallery a round of applause. And the reason I would do that is because as I've described, I think, I've been in this program a long time, and I know how hard the students work, but I want to call, and I thank you all for that. We all do. But I also know how important to the students' success is their support. And their support is in live situations, sitting out in the gallery. And your parents, your other relatives, siblings, friends, especially the coaches and the teachers that are in the gallery. They are a big part of this program. And I want to thank them as much as I thank the students, because they are important to the success of the teams and of this program. So thank you, all of you in the gallery. And I'll just reiterate my thanks to the students. We are not allowed a critique session because this is the last round of the tournament. And it's the rules, but I will tell you my impression, or my just one word response to what I've just seen is, wow. This is really why I volunteer as a presiding judge at these things. This was as uniformly superlative performance by both teams, witnesses, and attorneys, as I remember having seen in my dozen or so years of doing this. Just magnificent. I don't know if anybody could see me kind of grinning up here on the bench, but and I probably didn't do it overtly, but I just really tremendously enjoyed this. And it's because of the hard work of the students and the support of the coaches, the families, and the friends. So thank you sincerely for your efforts and for this particular performance. It was wonderful. And I know the panelists may still be completing their scoring process. And I suspect that their comments would be probably at least as complimentary as mine have been. And I'm sorry they won't get the opportunity. If this were live, they might stick around and talk to you if you wanted to afterwards, but I don't know that that's possible on this format. But in any case, I'm sorry that I can't, and I'm sorry that the scoring panelists can't tell you what a great evening you've presented for me, certainly, and I am pretty sure for the panelists as well. And I think your performance justifies their contribution to this process. So I'm done. Thanks to all of you. Have the Patrick and Michael and Josh, have you submitted your scoring sheets? All of you have?
No, I'm
Okay.
finishing up right now.
Okay, I don't mean to rush you, Michael.
Very difficult decision. This is like a jury being out for a couple of there, okay? So
all right, do it right. Do it right. Take your time.
I have to run and meet my wife for dinner, and I've submitted my score. Just want to chime in and say very impressed with everyone's performance. You all were fantastic. You guys are the reason why it's so much fun to volunteer, and might have to go talk to some of those other panelists who are weighing in on maybe becoming coaches as well, because you guys are very inspiring. You did a fantastic job. So best of luck in the future tournaments, and have a good night.
Thank you, Patrick.
Your Honor, during this brief pause, may I make a comment to the other team really quickly?
Yes.
I just want to say this was incredibly fun. You guys were exceptional. You know, it was so fun to get into these objection battles, to be able to do mock trial with you guys. It was awesome. So thank you for that.
Yeah, and same to you guys. This was so entertaining. We were so excited when we saw some familiar faces and we knew it was going to be a good round. So thank you guys so much.
Yeah, it's good to see everyone again. I know I saw some of you last year.
It was very exciting.
So very riveting.
David, do we have to wait to confirm that everything's been received?
I do before I release everybody. That's what we're waiting for.
I'll just say briefly, I was blown away, super impressed with both sides. It was really competitive, just extremely high level. So you guys should all be proud and good luck. I'm sure you're going to do very well. So congrats.
So should we consider Michael making this a hung jury for right now?
Close, but I just submitted, and I will say that this similar comments that, the level of passion and, I mean, we saw some passion in this too. I like that. And considering that this was a mock, or a moot court competition here, essentially, the level of passion was riveting, really. I felt like I was a juror in some ways, just listening to it. And the level of skill, the level of preparation, weaving in the appropriate rules of evidence was impressive as well. And the witnesses were all really excellent witnesses too. I mean, there were witnesses who were the plaintiff, who was appropriately tearful at times. I felt, I mean, we realized it was acting, but it was good acting. And your other witnesses were uniformly excellent witnesses as well. And of course, the attorney work was superb. So really, keep up the good work. I mean, you're just at the high school. I mean, I've seen work by moot court law students that was really, I mean, I don't want to damn them, by faint praise, but this is almost at that level. And really, in some ways, I didn't think I was listening to high school students. I thought I was listening to people that were in college or beyond, law school. So thank you.
Okay, well, having started this phase by saying you weren't going to get any critiques, I hope we've made up for any disappointment you may have had initially. So I think with Michael's submission, we are finished with this. Go to, I think it's courtroom 1 to get the results for the, I guess, call it the bottom line of your efforts, not just in this round, but in all of the rounds in this tournament. And thank you all again. This was a great experience.
Bye.
Good night.
Thank
Good
you,
night,
everyone.
everybody.
Thank you, Your Honor.